the court entered an order authorizing Mr. Jones to add the city of Atlanta as a necessary party because the city of Atlanta was, as far as anyone could tell, still the record deed holder of the abandoned alley, this abandoned Schuyler property. Then what I expected would happen is that Ms. Cummings filed a renewed motion to dismiss. But then the amended complaint sounded in quiet title and a number of other things, and may or may not have attempted to add new parties. It's a little unclear to me, and I'll let y'all know why I'm unclear on that in a moment. And so what I think I have in front of me now is a motion to intervene by Kelco, who is not currently a party to this action, although they're mentioned in, I think, paragraph 3 of the amended complaint. No summons has been issued to that party. They're not identified as a defendant in the case caption. And I've also received a joint motion to dismiss Matrix, who also is not a party. Now, I understand that they are the party in interest to NationStar, who is a named party and was served. But technically Matrix is not a party because nobody ever substituted them in. And so meanwhile, I think I saw in some of the email cross traffic that Mr. Jones's intent had been to dismiss all of his claims against the city of Atlanta because he's now purchased the property from the city, which of course Ms. Cummings has, I'm sure, strong opinions about what that implies about his ability, Mr. Jones's ability to have initiated this suit in the first instance. And the quiet title that might perhaps put this issue to rest, I think, is also intended to be dismissed. And so that mess of this case from a procedural perspective is sort of where we are right now. Who wants to go first and help me solve some of these problems and unknot some of this mess? Mr. Henderson, you have a motion to intervene pending, so why don't we start with you?
Yes, Your Honor. As the court noted, we are mentioned as a party. As you've seen in our motion to intervene, we hold a security interest as to property that Mr. Jones currently is involved in at 1097 Avondale, but also a security interest, as we understood it, in initiating the contracts in Schuler Avenue. We're named in the initial petition as well as the amended petition. We were never served. I believe that we are an indispensable party. I think that as laid out in our motion to intervene, we can intervene by right because we do have the interests in 1097 and Schuler Avenue. Those interests come not only from the security deed and the balloon note to which they're attached, but also from a purchase and sale agreement that was contemplated as part of the entirety of the deal. I've only just sent the court and counsel copies of my answer and counterclaims, but we have alleged counterclaims against Mr. Jones and against Ms. Cummings in quiet title, and then a number of counterclaims against Mr. Jones for breach of contract, breach of promissory note, specific performance in completing the sale, slander of title, conversion. So I think at this point, my request would be that the court delay this proceeding, consider the motion to intervene, allow our intervention, and then at that point, I think we would need to participate in some limited discovery to get in the same sort of standing as the other parties to this suit. But I do think it's very clear that Kelco is an indispensable party to this litigation, having claims of title and equity.
Okay, thank you, Mr. Kelco. Who wants to go next? Ms. Whitehead?
Good morning, Your Honor. Patty Whitehead here for NationStar/Matrix. I believe Mr. Robinson and I had contemplated a joint motion to substitute Matrix as a party, and then a joint motion to dismiss Matrix as a party. I'm having server problems right now, so I can't actually go and see everything.
Oh, the joys of technology.
Down.
Right.
Yes. But I know that is what we had contemplated. Upon review, our security deed on the property is only with, it doesn't involve Schuyler Avenue. Whether or not Ms. Cummings ends up the owner of Schuyler Avenue, or however this turns out, then maybe my client would have something against Ms. Cummings, but that is just not Right now, we only have a security deed on the border of the property without Schuyler Avenue. And
Okay,
that's why.
this is as good a time as any to let me ask you for clarification on that, because in terms of direct claims, that would all make sense. But to the extent that the amended complaint, which maybe Mr. Jones now seeks to dismiss that claim, it sounded in quiet title. The intervention that Kelco seeks to urge sounds in quiet title. Is it your position that that you're still not a necessary party to the quiet title because your secured interest only attaches to 1085? I can't remember the name of the road now, and not the alley that's behind it, the Schuyler property?
Yes, because at the time that all of this was initiated, that's what our legal description said. So down the road, when all of this is settled, maybe there's some kind of reformation claim only against Ms. Cummings, or we come to an agreement for that encroachment or something that's there, but that's just not, it's not there right now. And there's not anything that my client can add to the conversation other than we have a first priority security deed on Ms. Cummings' property without Schuyler Avenue.
Okay.
Your Honor, may I speak next?
Yes, Mr. Robinson?
Thank you, Your Honor. Ms. Whitehead is exactly right. There is a consent order which has been submitted to the court to substitute Matrix, and then Matrix changed its name to an acronym to be substituted for Nation Star. And then, as Ms. Whitehead said, we had filed a joint motion to dismiss Nation Star, Matrix, and the new entity. Likewise, after Mr. Jones obtained a deed from the city to the abandoned Schuyler Avenue, we filed a joint motion with the city to dismiss the city. And likewise, we filed a dismissal of the quiet title because at that point in time, in my judgment, there was no one involved other than Mr. Jones and Ms. Cummings. And so we then filed an amendment to the declaratory judgment because it seemed to me that really there were no issues to be resolved other than our request for a declaration that Ms. Cummings had no claim to the abandoned Schuyler Avenue. As to the claim of Kellum, that is a totally confusing situation because, first of all, I have never seen a signed note. There's reference to a note, but we've never been provided with a signed note. Secondly, it's totally unclear as to whether or not the $230,000 that's referenced in the note and the security deed was a loan or was it a down payment for purchase of 1097 Avondale Avenue and Mr. Jones' contemplated interest in the abandoned Schuyler Avenue. So we don't know what the nature of the $230,000 is.
Well, Mr. Robinson, let me interrupt you for 1 second, because I think that all goes to the issue of the motion to intervene and that has only just been filed, and to which I'm sure you intend to respond in the manner based on many of the facts that you're outlining right now in terms of there not being perhaps an interest and or a right to intervene.
Right.
One of the things I'm trying to get to, though, is because it does sound like there are a number of issues, but there are also a number of, and first, forgive me, I see all the emails where there's a motion to dismiss, a joint motion to dismiss Matrix, and I don't know if I've overlooked an email, but I just don't have a record of that substitution. So I apologize if I sounded naggy when I said that to start with, if you've already submitted it. So what I'm really trying to get to, though, is this started with a lawsuit by Mr. Jones against Ms. Cummings, alleging that Ms. Cummings was encroaching, that I think I understand that correctly, that her property at, is it 1085, was encroaching on this abandoned Schuyler Alley. Is that still an active allegation or issue or concern associated with Mr. Jones's ownership of, because I'm trying to figure out who are, if the case goes forward, who are going to be the parties that the court needs to look at and determine if there are interests in the party, if for nothing else than a quiet title action?
Your Honor, the main thrust of the initial declaratory judgment was to obtain a declaration that Ms. Cummings had no right, title, interest, or claim in and to the abandoned Schuyler Avenue, because in our conversations with the city, they kept saying they needed something from her. But then, now that Ms. Patrice Perkins Hooker became the city attorney, she clearly saw that the abandonment that was filed by and unanimously approved by the city of Atlanta showed that notice had been given to the predecessor entitled to Ms. Cummings, in addition to the fact that Jones' deed to a predecessor entitled to Ms. Cummings had excluded Jones's claim to the abandoned Schuyler Avenue. So all we were seeking primarily was a declaration that Ms. Cummings had no interest in the abandoned Schuyler Avenue.
Okay.
So at this point, we're back to that, in my judgment, is simply seeking a ruling that Ms. Cummings has no interest in the abandoned Schuyler Avenue.
Okay. And this is the same abandoned Schuyler Avenue that now belongs to your client, right? Because he was able to purchase it from the city of Atlanta in some recent time period?
Yes, Your Honor. Last Wednesday, that purchase was completed, and the Madam City Attorney recognized in my opinion, the viability of our claim and honored that, and the payment was made and the quitclaim deed was delivered, and then the joint motion was filed.
Okay. Hi, Ms. Perkins Hooker. How are you?
I'm fine, Your Honor. We are actually sitting outside of courtroom 4B because we never received notice of the Zoom hearing.
I'm so sorry.
And we did speak with someone from your office, so I apologize profusely for being late to the call, but I was here at 9 o'clock, couldn't get in, rang the office, and then we received this notice.
That surprises me because we have jurors coming in today for a criminal trial that starts at 9:30. So I don't know how we missed you standing out there, Ms. Perkins Hooker. But let me say this, what I had been doing so far, we have not been having any like argument about motions. It's more, everybody tell me what your position is about where we are.
Okay, all righty.
And
That's great. I can tell you that the city doesn't have any interest in this property. Your Honor added us because there was a concern about the city this was more of a quiet title action, and taxing jurisdiction should have been notified in event of a quiet title. However, we have no ownership interest in it because we abandoned this alley in 1994. Unfortunately, we didn't ever get a chance to finalize the conveyance of the property until last week. I'm new to as a city attorney. I came in on May, and when this matter was brought to my attention in August, I started looking at it and said, yeah, he requested this to be transferred in 2022, and it fell through the cracks. And so I went through the process since the city council had already approved the abandonment. I do have with me Attorney Alexander Hamilton, as well as our real estate director from the city, who was willing to be here to testify with regard to the city's processes for dealing with abandoned property.
thank you, Ms. Perkins Hooker. I appreciate that very much, especially on such short notice.
Yes.
Mr. Robinson, was there anything else you wanted to add before I call on Mr. Howard?
I don't believe so, Your Honor. Thank you.
Mr. Howard?
Well, Judge, I think we're here because my client filed a renewed motion to dismiss.
That's right.
And so if you'd like me to argue it, I'm happy to. Like the other parties, I'm still getting my head around what the recent amendments and the motion to intervention mean. So, it may well be that there are some new claims that exist that we haven't moved to dismiss yet. I just haven't had an opportunity to get my head procedurally around all of that. I will tell you this. We filed our initial motion to dismiss because it was clear from the affidavit that Mr. Jones had filed in the real property records that he did not own this property, that he was trying to buy the property from the city of Atlanta, that he had a contract to purchase the property from the city of Atlanta, and that he swore publicly that his claim to this property was established based on the election to purchase.
Right.
Therefore, he had no right to eject my client from property that he did not yet own, and he had no right to a declaration that he owned property that he did not
Forgive
yet
me
own.
for interrupting you, Mr. Howard, because I am familiar with the basis of your motion to dismiss and the basis of the renewed motion to dismiss. But I think part of the reason that everybody's saying we all need to sort of sort this out is I understand that I'm not saying that I can just wave a wand and fix all of this. There are legal and procedural requirements that have to happen first, and I understand that. But at its most basic, one thing I'm trying to figure out is, it sounds like there is an ongoing potential dispute, whether it's in this lawsuit or another, between Kelco and Mr. Jones. But if the declaration that was sought by Mr. Jones was that Ms. Cummings didn't own the property, then now Mr. Jones has a deed that says he owns the property that he wanted a declaration for. Then why is the underlying, and I'm not saying I'm going to rule that way today because I think it may not be appropriate procedurally, but why is the underlying lawsuit between Ms. Jones or Ms. Cummings and Mr. Jones not null?
That's our question as well, Judge. It still remains for Jones to take a position on whether he has owned this property since he sold 1085 a long time ago,
Right,
or whether he owns it now because he's bought it from the city of Atlanta.
right,
He seems to have filed an amended declaratory judgment action, which states that he owns it because he just bought it from got title from the city of Atlanta. And he claims Ms. Cummings cannot have adversely possessed property that was previously owned by the city of Atlanta. So he seems to be admitting now that the city of Atlanta has owned it up until he got his quitclaim deed.
right. But I guess where I'm confused, to
Mhm.
just put a fine point on it, is other than being sued and brought into court, is Ms. Cummings claiming any entitlement to the Schuyler Avenue property?
Well,
Other than the fact that she got sued and dragged into all this.
there's this alternative position that they've been advocating, Judge,
Right,
which is that the quitclaim deed is just a confirmation of what they've been saying all along, which is that they actually owned the property
right.
since back when.
Yeah, no, I understand.
Okay.
But
If
my
they
point
follow
is,
that,
yeah,
if they follow that path, and if that's what is in fact true, then when the city abandoned the property in 1994, Mr. Jones did not own either 1085 or 1097. The property was owned by predecessors to him. And if what he's saying is correct, is that it's, quote, black letter law, which is his position, that Schuyler Avenue at that point became divided in half and attached to the adjacent property, then it's shown on the face of his petition that he doesn't own Schuyler Avenue because it was never conveyed to him by his predecessors in title, and those deeds are clear on their face. So if that's the case, Ms. Cummings would have a position that she adversely possessed the portion of Schuyler Avenue inside her back fence, not from Mr. Jones, but from
But
his
from the
predecessors
city.
in title. So
Okay.
she may have a quiet title action, and on top of that, she may have an action against the city of Atlanta for failure to follow its own procedures with respect to this abandonment. So
Okay.
we have claims. Now, whether we're going to assert them or not is this other issue. A lot of it's going to depend upon discussions probably between me and Mr. Henderson, but I do believe, I mean, based on your Honor's question of why is this not null, I do think as to Mr. Jones, this action is a nullity, and I think for a couple of reasons. One, because if he's admitting now that he just bought the property, then he's also admitting that he never had a basis to sue my client to begin with. And I think that's a fraud on the court. And this whole thing needs to be dismissed as a sanction. If this lawsuit goes away, then Mr. Jones and Mr. Kellum can litigate against one another, and Mr. Kellum and Ms. Cummings can work out whatever they work out. But there's absolutely no reason that Ms. Cummings should have been dragged into court under a claim that Mr. Jones owns title to property that in fact he just bought from the city of Atlanta. And there's so many, I mean, we tend to file a motion for attorney's fees about
Well,
this,
I
but
assumed that based on the arguments that you've previously made every time I've seen you.
right. But if there's really no reason for this lawsuit to exist between him and her right now,
Well,
because
that's why I asked the question, because if Mr. Jones has resolved his claims with Miss Cumming, I'm sorry, with the city of Atlanta, theoretically, and Mr. Jones has resolved the claim or the involvement, at least, of Matrix. And depending on his posture relative to Miss Jones, that informs the court's consideration about an intervention versus this case is no more. Y'all go do whatever you wish to take, whatever action you wish to take relative to one another. And that's what I'm trying to figure out. And so that's why I sort of insisted that we attempt to move forward with this hearing today, because I understood that parties were moving around and people were changing things. But at the end of the day, this hearing was about whether or not Ms. Cummings was a proper defendant or a claim had been stated against her. And respectfully to Mr. Kelco, I know I saw an email request saying that, you know, that I needed to rule on his motion to intervene, but the court's understanding is that if the city of Atlanta isn't a party because everybody, the two parties, city of Atlanta and Mr. Jones agree. And they agree that Matrix should not be a party or can be excused. And if the court were to grant the dismissal as to Ms. Cummings, then the motion to intervene is moot. And then the parties can go file whatever lawsuits they want to file against each other. So that was why I had always insisted or sort of ignored y'all when you asked me if we could please move this hearing, because it feels like every time we get to a potential hearing on this matter, we end up with a new set of complications. So let me start with something I hope is simple. Ms. Whitehead's client. Now, the only concern I have about any of these parties is the extent to which, if this case moves forward, there is the need to keep any and all parties who might have a record interest in the property, which would include Matrix, potentially. Although I think I understand Ms. Whitehead to be saying that they believe their security deed, right, that it is limited to the internal four corners of 1085 and wouldn't be implicated in any discussion or argument other than maybe a later reformation of the deed if it turns out that Ms. Cummings had adversely possessed some portion of the Schuyler Alley. Is that roughly accurate? Did I capture that correctly, Ms. Whitehead?
Yes, Your Honor. And any kind of reformation claim, that would be a separate issue from what's involved here, because then it would be established who owns what.
Okay.
Your Honor, may I speak to that point too?
Yes, sir, Mr. Robinson.
Thank you. We sent requests to admit to Ms. Whitehead, and that was the basis for the consent motion and order that they had responded that they had no right, title, claim, or interest into the abandoned Schuyler Avenue. And so that's why we thought it was appropriate that Nation Star Matrix and its successor by name change be dismissed from the case.
Okay. And to the extent, Mr. Howard, do you have a dog in that fight in terms of any concern or objection about Matrix being released under those circumstances?
no, Judge, I'm not sure why they were sued to begin with. We don't have any concern about them being dismissed. I just would note for the record, since Ms. Whitehead is here, I do not know what legal basis they would have to take action against Ms. Cummings if by adverse possession she somehow, establishes title to a different piece of property.
Okay. Now, Mr. Kelco, I'm sorry, Mr. Henderson, your client's not technically a party. But to the extent that the only thing that gives me pause is because I feel comfortable saying claim against this, who the cross claims are against and what interests are implicated. The only thing that gives me pause is because at base, what this always should have been, if it was anything, was a quiet title action that a special master could have sorted out. But Kelco, assuming they were a party or are an interested party, whether they're a legal party yet or not, have an objection or interest, concern about the release dismissal of Matrix?
No, Your Honor.
Okay. So Ms. Whitehead, you might be able to get out of this mess now and go ahead and head on your way. I do have a motion to, I will find the motion for substitution and make sure that it gets docketed in the appropriate order. Once that substitution order is entered, or that notice of substitution is entered, then I do have the proposed dismissal, and I can go ahead and dismiss Matrix based on that joint agreement to do so. So that means your client's role here is done for now.
Thank you, Your Honor.
Thank you. Okay, so that takes me back to the city of Atlanta. And this is where Mr. Howard and Mr. Henderson, I have a question for y'all in terms of, there is also a motion pending to dismiss the city of Atlanta based on the completed purchase or completed, sale and transfer of the property between Mr. Jones, the Schuyler Avenue alley, between Mr. Jones and the city of Atlanta. But given the potential issue associated with a prior effort, prior actions or lack of action taken by the city of Atlanta that might have resulted in some sort of subdivision and attachment. I'm sure I'm not using those technical legal terms in any way that's appropriate, but is it appropriate? I mean, right now, the main claim, if you dismiss the quiet title, is a claim directly at City of Atlanta, which would seem to have been distinguished by the purchase. But how is City of Atlanta not still a proper party if we are dealing with quiet title potential issues, Mr. Howard?
Your Honor, I think
Yes.
that there's one thing I want to point out.
Sure.
This alleyway was abandoned, conditioned upon the receipt of payment.
No,
And-
I'm Miss Perkins Hooker, forgive me, but I've heard this argued to me, and I've reviewed all the pleadings and all the
Okay,
motions,
good.
and so
All
I'm
right.
familiar. The issue is, I think, as I understand it, that it was abandoned, that there was a process that had to be followed by someone, but Mr. Jones has taken the position that his intention to purchase, right, was sufficient to imbue him with some interest, that was then finalized recently. Now, I'm sure Mr. Howard's position or Mr. Henderson's position might be that property was just sitting there and nobody did anything with it until at minimum 2022, but certainly until now, when there was an actual deed to transfer the ownership of the property.
And the only thing I wanted to point out is legally, you cannot get adverse possession against the city.
That was, I remember that from property law, but you guys are giving flashbacks to first year property law. So
the nightmares associated with it, right?
Indeed. If somebody says the rule against perpetuities, I might have to hang up, but.
Right, but since you can't get adverse possession, Mrs. Cummings' time frame to even start having an adverse possession action wouldn't have occurred until she obtained the property in 2017. But her predecessor in title had a reservation of interest in this Schuyler Avenue property because of the fact that Mr. Jones was aware of the fact that the city had purchased it when he conveyed it to her predecessor in title. So in that chain of title, her second development took the property subject to this reservation of rights. So she is therefore bound by that deed. And so there was no way to have an adverse possession if everybody knew about the alleyway and the interest in it was reserved. There's no way to get an adverse possession.
No, I mean, I'm not disputing that, although I understand that the circumstances of all of that and the deeds that you've just recited, I know are a subject of much disagreement between Jones and Kelco and Ms. Cummings. But my issue is to put a finer point on it. As I said, I understand if it was a strict claim by Mr. Jones against the city of Atlanta, that claim would seem to have been distinguished by the two parties indicating that their dispute is resolved.
Right.
But my question to Mr. Howard and Mr. Henderson is if they have a position as to whether the city of Atlanta must still remain a party as they were, in this action or some other. And keep in mind, I'm not trying to just dump the case, because if y'all refile in any version, I'm going to end up with it again as a related case. So I'm just trying to be efficient and figure out who are the actual parties that have a dispute here and where is this case going.
But Your Honor, there's no counterclaim filed by the defendant against the city. None. So there wasn't a counterclaim or against Mr. Jones's representation about the city or the city. So we were only in there because of your order asking us to be added as a part of a party. So when we resolved the ownership interest that Mr. Jones had initiated in 2022, we should be let go, because we're not, whether or not there's somebody who owns the debt on the property, whether or not that they have a dispute between each other, has nothing to do with the city of Atlanta.
Right. I understand that, Ms. Perkins Hooker, as in terms of the city's role now. But
Okay.
I think I understand the parties to be saying that how this occurred previously and how what occurred previously was recorded or not recorded in various property filings, deeds, security deeds, etc. Everybody knows what the city of Atlanta's interest is in that property right now, because there's a deed that reflects it that is relatively recent. But I think I understand the parties to be saying that the city of Atlanta's relationship to that property and the adjoining owners after it abandoned the property in 1996, I think, or 4, that is a matter that might have to be sorted out. And so that's the only reason I'm asking about the city of Atlanta's role in the case. Mr. Howard?
Judge, I will tell you that the short answer to your question is I don't know yet.
Okay.
Because we were in receipt of some document discovery from Mr. Jones Thursday evening, I believe. And it includes hundreds and hundreds of pages of information, including information related to Mr. Jones's efforts to buy the property from the city. I'm also in receipt of production of documents from the city of Atlanta, and I've had some discussions with Attorney Hamilton about that, the scope of the production, and what, and we're trying to find out what the city did and all of that. I understand from the city's perspective, they have a data breach issue where they may not have access to some of the documents. It may remain a mystery what happened and how Mr. Jones ultimately was able to get this quitclaim deed. But it seems to me that if the path that everyone is taking is that the city abandoned the property in 1994, and that abandonment was subject to appraisal, sale, and receipt of the money, which would be consistent with the city ordinance, or excuse me, the city code, and the way the abandonments typically work, then Mr. Jones bought the property from the city of Atlanta. Whether he did so properly or improperly, maybe for a different case. But if he just bought it from the city of Atlanta, then I don't know why the city would be in this particular case. But I can't take a legal position on that. It's all happening in kind of real time here. I apologize.
Yep, I know, I understand. Mr. Henderson, again, not a party, but.
Yes, Your Honor. I think at this point, I don't foresee my client having a claim against the city of Atlanta, but I do see the possibility that Ms. Cummings would have that claim. And so I obviously can't speak to how that claim would be alleged, but I think sort of maybe going more to the heart of the question the court asked, I think if this action is dismissed, what's going to happen is a new action involving all of the same parties is just going to have to be filed regarding the entirety of the same subject matter. It's going to be Kelco, Ms. Cummings, and Mr. Jones litigating the same issues. There's still the issue of...
Except that Mr. Howard's position all along has been Ms. Cummings was never a proper party in this action because Mr. Jones never owned the property. I guess maybe now that he owns the property, he might be, it might procedurally put it in a different posture, I guess, but.
Yeah, I think that's a question that remains to be answered, whether he did or did not own the property. I understand that a new security deed has been entered, or rather a quitclaim deed, but I think that there are claims remaining. There's also the claim that Ms. Jones has filed in her counterclaim regarding adverse possession, which would affect my client's interests. So I would have to involve her in the quiet title as well. So again, I think we just end up back here with Kelco, Ms. Cummings, and Mr. Jones. And so,
And why?
Judge, one comment in response to Mr. Henderson.
Yes, Mr. Howard.
I did manage to read his counterclaim that he filed this morning, and
Yes.
Mr. Kellum is taking the position, like Mr. Jones is now, that the city has owned the property. He's affirmatively taking the position that the city has owned the property, and therefore Ms. Cummings could not have adversely possessed it from the city. So I do not think, from Mr. Kellum's position, that it is an open question at all. In fact, I think he's judicially admitted that the path that he's taking. He affirmatively alleges that the city owned it until just last week. I'll also note that in the discovery that I received, apparently Mr. Kellum and Mr. Jones had been in extensive discussions with the city, and amongst them, they shared the opinion that the city was concerned about selling the property to Mr. Jones because they believed they would be opening themselves up to a claim from Ms. Cummings for failure to follow their own procedures. That's
Your Honor,
Ms. Perkins-Hooker, your connection is, Ms. Perkins-Hooker, sorry, your connection is weird since you're standing right outside my courtroom, but
yes, I am.
try again, Ms. Hooker. I heard you start to speak, but I couldn't hear you. Try again.
Can you hear me now?
Yes, ma'am.
Okay, Your Honor, I said that particular statement, I objected to Mr. Attorney Howard's characterization of that. There was no official person from the city of Atlanta who made any of that type of statement, because the only person who can do that on behalf of the city of Atlanta is the mayor. And talking to a real estate agent doesn't work. But what I wanted to say, Your Honor, is that the Kelco's action has nothing to do with the city. If he wants to foreclose on something, that action has nothing to do with us. If he has an interest against either Mr. Cummings, Ms. Cummings for or not for that alleyway, then he needs to fight that fight with Ms. Cummings if that's valid. But the city's alley, the city of Atlanta never acquiesced, signed, consented to any security interests on the alley. And
Right.
so when
I
they
understand all that.
they shouldn't be in this action.
The issue that I'm having is, again, I understand there was a direct claim that was asserted against the city of Atlanta, and it would appear to have been resolved between the two parties that were involved. But there was a quiet title action, and generally when a case starts because there's a mess and a dispute about who owns what interest, then what I always want to do is, well, then let's quiet title it. Let's everybody figure out what the interests are. And so the only reason that I'm continuing to ask this question about the role of the city of Atlanta, and I understand your defenses and disputes about any claim that might be brought against you, is simply based on my concern about the city of Atlanta's historical role in the ownership of this property that is in dispute in my case, with at least one, apparently now dismissed, but quiet title action, and a new quiet title action sought to be asserted by Mr. Kelco, or by Kelco by Mr. Henderson on behalf of Kelco. And so that's the only reason I'm asking, Ms. Perkins-Hooker. It's not that these are all just representations by advocates. I'm not, accepting it as the gospel, whatever these issues are, that might be a dispute. To the extent that okay. To the extent that Mr. Henderson is raising a motion to intervene, and if allowed to intervene, is asserting a quiet title action.
Your Honor,
Yes, sir, Mr. Robinson.
may I make 2 points?
Sure.
One is, I would appreciate, the allotted time to respond to this motion to intervene.
Oh, I've already said I intend to give you that. I
Thank
mean,
you.
it's too
Yeah.
preliminary at this point.
Yeah. Secondly, as to the statements made by Mr. Howard, when we first got involved in this matter, one of the first things that was done was to tender to the city of Atlanta the payment pursuant to an appraisal, and to try to consummate the acquisition from the city of Atlanta. And unfortunately, there were two separate tenders made, and they fell on deaf ears because unfortunately Ms. Perkins Hooker was not involved at that point. So I think that Mr. Jones has proceeded correctly because the information we got from the city is we now need Ms. Cummings to sign a statement that she has no interest in the alley / abandoned Schuyler Avenue. And we sought to resolve that unsuccessfully. And that was why the declaratory judgment was filed. And I think based on the city's approval unanimously of the ordinance and the subsequent events in 2022, that was an appropriate avenue to pursue because at that point, we didn't need to quiet title to the abandoned Schuyler Avenue because we knew who the ownership was. It was the city and Mr. Jones' interest by virtue of having elected to purchase it and tendered the price to the city.
I understand all that, Mr. Robinson.
Thank you.
Here's what I'm trying to get to.
Okay.
The motion to intervene is premature for me to rule on currently because it was just filed and the parties, Ms. Cummings especially, and Mr. Jones need an opportunity to respond and state their position on whether or not Kelco has standing to intervene, should be allowed to intervene. And then if they were allowed to intervene, the reason I was asking the question is if they were allowed to intervene, one of their claims sounds as quiet title. And that would potentially not implicating any dispute between Mr. Jones and and the city of Atlanta, or even Ms. Cummings in the city of Atlanta, but it would implicate the city of Atlanta as a party, potentially. I mean, in the sense that they would be in the chain of title. That the only reason I'm getting to that point is what I'm trying to, so if I can't rule on the motion to intervene, I've already let Matrix out, but it occurs to me that as much as I hate that this ball keeps moving down the road, I think this was originally set for a hearing on August the 30th. And then despite, I think it seems like everybody's working to try and figure it out, and take steps to move it forward. But we still haven't gotten there. And what I still am trying to figure out is when and how to get to the motion to dismiss that has been renewed by Ms. Cummings relative to the claims by Mr. Jones. Here's what I think I'm going to do. I think I'm gonna have to reset this matter again. Because what I'd like is an opportunity to address the motion to intervene, figure out who the parties are that will be moving forward. In other words, if I don't grant his motion to intervene, or if I do grant his motion to intervene. At that time, I will also take up and deal with the requested dismissal of the city of Atlanta, which I understand is a joint dismissal. And please do not misinterpret what I'm saying, that I'm not going to ultimately dismiss the claim by Mr. Jones against the city of Atlanta as has been requested. It's just that procedurally, if the city of Atlanta is going to be a party in the case anyway, I'm going to let that play out for a moment and see how that goes. And then that will be, and then at that point, Mr. Howard, I think, will have had more opportunity to determine the extent to which Ms. Cummings is going to continue to be a party going forward, writ large in the whole case. And then I can figure out what to do in terms of a dismissal of the initial claims by Mr. Jones against Ms. Cummings, which are the subject of the dismissal, the motion to dismiss and the renewed motion to dismiss. Any questions, thoughts, concerns about that approach?
Quick question,
Mr.
Judge.
Howard? Yes, sir.
I have not seen a notice filed that the city of Atlanta was actually served with process in this case. I know an amended summons was issued, but it would be helpful if they're going to be a party to the case, to have notice filed, because that obviously starts their deadline running to answer, so forth.
Yeah, I perhaps I looked at the wrong thing, but, yes, I have that, it's docket entry number, let's see, 30, on August the 29th. I'm looking at an affidavit of service on the Honorable Andre Dickens, Mayor of the City of Atlanta.
Okay, thank you. Sorry.
That's okay. The only reason I was sure that had to be there, Mr. Howard, is because I had been nitpicking about so much other procedural stuff in this case. I was sure that the city had been served.
So the city may want to open default or file as a matter of right within 15 days.
Okay, so that's what I'm going to do. I'm going to give you, so if the motion to intervene, I'm assuming will become of record today. I don't know when it was actually filed, Mr. Henderson. I mean, I'm looking at both of them, but they're still not in the docket.
Yes, Your Honor. I'm sorry. I was in a hurry to try and get them to the court and counsel for this morning, and I'll make sure they're filed shortly.
Okay. So if they're filed today, then that will mean that they'll be due, a response will be due unless the parties were to agree to expedited handling. A response would be due on October 30th. Well, technically technically November the 4th. Nope. Yes. November the 4th. So that is a motions week for me. And so I could hear this matter. I think it would be set to hear it on November the 7th, which is a regular motions day for me. And we could sort it all out then.
That sounds perfect to me, Your Honor.
Mr. Howard?
Thank you, Your Honor.
Judge, I may be traveling on November 7th to Philadelphia. My firm does mock trial training for first year.
Fun.
So.
I coach the Mercer Intrastate Moot Court team. So I'm all for that. And I encourage lawyers to do that because that's the only way to make good new lawyers, right? Here's what I'll do, Mr. Howard, is I'm going to go ahead and notice it. Once you figure out what your schedule is, I typically try to keep my Fridays open. And so maybe I could hear it on that Friday. If that's better for you than November the 8th.
No, worse, Judge.
Worse.
8th, 9th, and 10th, we're training young lawyers. The 7th, I should be traveling, but maybe I'll just travel very late. So if we did it in the morning, that would potentially help.
Yeah, it would be first thing in the morning. I almost always schedule my hearings for 9 a.m. So as I said, I will set this matter for November the 7th at 9 a.m. And if there is an issue with your ability to attend, just let me know. And we will work out the scheduling to the extent that we can accommodate anyone. Matrix, I am going to go ahead and get that order of dismissal on file. The City of Atlanta dismissal is going to wait until that November 7th date when I figure out what we're doing with the intervention. And then we'll go from there. Yes, Ms. Perkins-Hooker, did you have a question?
I did, Your Honor. Attorney Howard indicated that there had been an answer filed from the city. We might need to open default.
Yes. I think what he was saying, he didn't know that y'all had been served. And I had pointed out that the record indicates that y'all were served on October the 29th. I don't see an answer. But there's I don't know when your answer would have been due, if it was due. I mean, if it was because of the 31st. Yes, Mr. Howard did indicate that the city should probably consider whether they have filed an answer and if they need to open default.
And the issue we have is we had settled the case to the parties that involved in it. So we found an answer.
I apologize. Ms. Perkins-Hooker, you're still breaking up on me. I'm sorry.
Can you hear me now?
A little bit better. Yes, ma'am.
Can you hear me now, Your Honor?
Yes.
All right, well, we did.
Nope. Okay. Ms. Perkins-Hooker, I apologize, but I can't hear you at all now. Okay. So what I'm going to do then is look for everybody's responses to the motion to intervene. Ms. Perkins-Hooker? Yes.
Can you hear me now?
Yes, ma'am.
Okay, what I'm saying is, the reason we probably didn't file an answer is because we had settled the case with a joint consent motion to settle it. So can we have, now that we're not ruling on that in a timely manner, can we go ahead and have an extension to file an answer or open default to file an answer?
We would have no objection to that.
Did you hear me?
Yes, ma'am, I did. And Mr. Robinson was indicating that he had no objection. I'm just looking at the calendar to figure out something really quick. Yeah, so if y'all want to put some sort of stipulation together, then I think that would probably be fine, Mr. Robinson, Ms. Parkinsucker.
Be glad to do that. Thank you, Your Honor.
Thank you. Thank you all for your time and for your patience with me. I will see you guys on November the 7th and we'll sort this all out. Okay.
All right.
Thank you
Appreciate it.
all.
Thank you.
Thank you, Judge.
We are here on the attorney's fees, part 2 of the Scott Jones versus Jennifer Cummings saga. Mr. Howard, I'm gonna start with you because technically it's your motion to recover attorney's fees, but you are sort of in the pole position in the sense that I've already said I'm going to award attorney's fees for you, and you've submitted an application for the entirety of your attorney's fees, which
Almost.
I think. Right, but I think it's about $122,000. Is that right?
That's very close, Judge. Yes, ma'am.
Okay. And so if you want to very briefly, I will, what I think would be helpful, because as I said, you start in that position, that it would be helpful for you to just very briefly outline what that entitlement is.
Sure.
And then let me throw it over to the other parties that want to challenge it and give you the last word to respond. Because as I said, that's sort of the position that we're in. Mr.
Yep, thank you. Well, so Judge, I appreciate it. And having gone back through my bills a couple of times, I have tried to separate out the work that we did that was related to the issue of, did Mr. Jones actually own this property? When did he acquire title to this property? Did he actually file an application for abandonment for this property within a couple of years prior to this case, as he says he did? And much of the work that we did was trying to dig out factual issues that we could not get resolved because he was making a false claim that he actually owned the property and had legal title to the property, which he didn't have. So I'm not going to dig back in and say all the incendiary things that were said in the prior motion, but the vast majority of this falls into probably, I would call it, 4 phases, right? Phase 1 is he filed his initial petition and he had 3 counts. Count 1 was declaratory judgment, and he is asking for a declaratory judgment that he already owned the property and that he was the sole and exclusive owner of the property, which we know was false. Count 2 was he was seeking ejectment of Ms. Cummings, and count 3 was for attorney's fees under 1367 or whatever the chapter title 13 attorney's fees code is, Judge. And that's what ratcheted up the need to try and figure out, does he actually own this property? Because he's saying she's on my property and she's got to get off of it, which we know is not true. So most of the pre-motion to dismiss work, which I would call the first phase of the case leading up to the hearing on the initial motion to dismiss, was trying to figure out 2 things. Thing 1 was, what is this less than accept provision? And thing 2 was, does he really have title? And what you'd see in my first invoice is that I have 8 hours of time for which I no charged Jennifer Cummings. And that 8 hours of time for which I no charged Jennifer Cummings is me doing things like going back and reading law school treatises and stuff like that, trying to figure out, what is this less than accept provision and can it be binding here as a matter of law? That's my research on those issues. There may have been 10% or something of that invoice that was me and Madison McMichael going back and forth about that stuff. But I basically told her, this is what we're going to argue, do this. She drafted a motion to dismiss. But the vast majority of the of the work in the first phase of this case was just trying to figure out, he claims he owns this property. How is he saying this? We don't understand it. I would say phase 2 of this case was after and plaintiff claims that we didn't win any of our motion to dismiss. I think Your Honor actually held it in abeyance, although we did win something because Your Honor said you agreed with us that the city of Atlanta was a necessary party to the litigation, which was an argument that we raised. And by getting the city of Atlanta into the litigation, ultimately we found out who did own legal title to the property because they sold it to Mr. Jones during the second phase of this case. So the second phase of the case, Mr. Jones did a couple of things. The first thing was that he did not, as he claims, haul off and immediately file a quiet title action. What he tried to do was he tried to do something called vouching the city of Atlanta into the litigation.
I remember because then I had to go look at treatises and figure out what vouching someone in was. So
that was interesting. Legally, I do not believe that vouching would have worked, and he must have ultimately agreed because we got an amended pleading in which there was a quiet title claim. Their position on the quiet title claim is that Your Honor told us we had to do it, and they're sort of reasoning their way around to that by saying, well, because of sovereign immunity issues, we had no other means of getting the city of Atlanta into this case. First off, I'm not sure that that's correct. I think they potentially could have sued the city of Atlanta for breach of contract, but without getting into all of that, certainly what the court did not do was tell them that they should file a quiet title action based upon a false claim of ownership, which they knew to be false. So, in order to quiet title, they have to have legal title at the time that they do it. So they filed their second amended complaint. They filed all of the documents that they filed attached to the second amended complaint. A number of revelations came from that. And I would say in that second phase of litigation, I would call that the phase where we were finding out about J.D. Kellum and his company Kelco and all of the other conveyances that had been made regarding the properties at issue in this case. And so that was a process where now I had to reach out to Kelco, who I did not realize was apparently good buddies with Scott Jones and in a financial relationship with him. Did some discovery, some informal discovery, and then some formal discovery. Met Mr. Kellum's attorney, got some documents, and realized that even if Mr. Jones owned this property as he claimed, he would have given a lien to Mr. Kellum's company, which means that he also didn't have a basis to quiet title. So figuring out all of that was the second phase of the litigation. And then the city of Atlanta, once they got into the case, there was some back and forth doing discovery, trying to figure out from them whether they actually claimed that they owned the property or not, because they were a little cagey about that. I spent some time throughout the invoices going back and forth to City Hall because the city of Atlanta, I guess, changed attorneys during the time of this case. There was one city attorney, and then it became Ms. Perkins Hooker. And the counsel that was actually corresponding with me about discovery requests departed, and the city never told me that she was gone. So I spent several weeks, I would say, emailing back and forth with that lawyer, never getting a response. Eventually, I went to City Hall. I went to the law department. My goal was to try and figure out two things. One, does the city actually claim that it owns this property? And two, has there been an application for its abandonment? And the reason I wanted to know that is because if Mr. Jones, as he claimed, was applying for abandonment of the property currently, then he must know that he didn't own it, which would prove the point that I've been trying to make this whole time, which that he doesn't own the property. I got ran around City Hall for probably a day and a half of people sending me to a variety of different offices before someone finally told me that the attorney had changed and they were sorry. And an attorney named Alexander Hamilton finally corresponded with me. Nice guy. Gave me the documents and assured me, well, this is what we're going to do. We're going to sell the property to Jones, and we're going to leave you to fight your litigation fees battle with him. I was a little surprised to see Patrice Perkins Hooker's affidavit attached to their motion, given the fact that their position was we're going to sell them the property and stay out of it. Nevertheless, she filed one. I don't think she said anything that harms our motion or Your Honor's ruling. So that was phase two of the litigation, leading up to, on September 27th, them disclosing, or September 25th or thereabouts, disclosing that they had a quitclaim deed to purchase the property. I think Your Honor may have remarked during the hearing when it was disclosed, Mr. Howard probably going to have something to say about that. That's about the time when I started looking at, what is the viability of a fees claim in this case. I know they complained that we started working on a fees motion prior to litigation concluding, but once I realized that the claim of ownership was factually and demonstrably false, I spent an hour or two looking at those issues, and then the bulk of the fees work was later. The third phase of the litigation, I would say, happened after that. This was the point when I really thought the case probably should be over, but somehow wasn't. The plaintiff's lawyers, you'll recall, dismissed all of their claims except for they refused to dismiss their Title 13 fees claim, Judge. And so I had to file a motion to dismiss that, which was ultimately granted. And they claimed that, well, we continued litigating our declaratory judgment claim after the quitclaim deed was issued, which I think Your Honor must likely, because you denied their motion for attorney's fees, must have agreed with our position, which is that we told the court that we were probably going to dismiss it voluntarily and that there wouldn't be a need to consider the motion. We were just waiting to see if the transactions happened as they said, where they were going to sell the property to Mr. Kellum. Before that, Your Honor entered a motion dismissing it as moot, which is fine. It's not a ruling on the merits, but I don't think that mitigates against our fees. I think the fact that they continued litigating against my client for attorney's fees after this case was over really weighs in our favor, Judge. So then really the final issue is our motion for attorney's fees and their motion for attorney's fees. They seem to have a complaint that we spent $60,000 in fees moving for fees. That's not quite correct. We spent maybe half of that as an amount of money moving for fees. So call it half of the 60 grand, 31 or something like that. The other half we spent defending their motion for attorney's fees, which was again based upon their claim that he owns this property. So because we had to defend all of that, I would say that was all necessarily caused by his false claim of ownership.
Sorry, I was just, my assistant was bringing me more coffee. Sorry about that.
Not a problem. I just wanted to make sure I gave Your Honor opportunity to deal with whatever. So, Judge, most of all of this has been about what is, does he really own this property or not, as he claims? And we never quite got straight answers to any of those questions. I'll note that we did not get disclosure of documents from plaintiff's counsel in response to our request for production of documents until after the quitclaim deed was disclosed to everybody. So they had told us that we would be getting production of documents. They delayed and delayed and delayed, and we were waiting to see what those documents were. And Your Honor knows what most of them are because they were attached to our fees motion. And they absolutely would have, if they'd been disclosed timely, demonstrated that Mr. Jones and his counsel knew that the property was owned by the city of Atlanta at all these times. So they delayed production of documents. Ultimately, we were scrambling once the quitclaim deed was disclosed to go read their production, which got made later, figure out what that said and figure out how it supported our fees motion. I do not believe $30,000 for a fees motion in a case like this is that outrageous. Their claim seems to be that I over litigated everything, but there were I would say 90% of the pages that we filed in our fees motion were just trying to lay out the actual factual timeline of this case and how the facts progressed. And that took a lot of digging because nobody wanted to disclose anything to us until the quitclaim deed was disclosed. And after that, they seemed to take the position that, well, it's all over now. Here's the documents, you go figure it out. And going and figuring it out is what laid the foundation for our ability to file this motion. So
yeah, let me ask you a quick question, and then I'm going to respectfully cut you off and go to your opponents, and then, as I said, give you an opportunity to respond. But
thank you.
One thing I would like clarification on is you said they have asserted that you spent roughly $60,000, half of the fees that are being sought to be recovered on attorney's fees. And I think I understood your argument to be at least half of that, 30 of the 60, was in defending the fee motion they filed. And so that would mean the other half of it was in filing your own fee motion. Is that roughly accurate?
I think that's the breakdown, Judge. I could get you a specific number if it's going to matter, but I think essentially we filed our fees motion and they filed their fees motion on the
Right.
same day. And then we had to go defend their fees motion. So that was the next phase of it.
Excellent. Thank you, Mr. Howard.
Thank you, Jeff.
As I said, I'm gonna cut you off now and go on. Am I gonna hear from Ms. Jett, or who am I gonna hear from first, or all together?
I think, Your Honor, Ms. Bryant's going to go
Yeah,
first.
I'll
And
go
if I
first,
have
Your Honor.
anything for cleanup, I can be
Okay.
very
Good
efficient on
morning.
that.
Good morning, Ms. Bryant. How are you?
I'm okay. I do want to state, just as an initial matter, that I'm a little bit frustrated with the amount of time that we're being given to defend this. We have an expert who's here to testify. I will make a very brief legal argument, and then I'd like to put him on the stand to ask him some questions
And Ms.
about.
Bryant, I will have additional time if it's necessary to have a more fulsome evidentiary hearing, if that's what the parties think is necessary. Forgive me, but my sort of, we have so many affidavits that I've had a chance to review that I thought that the legal argument would be the focus today. And so, but again, I can, I can give you more time. It's just not going to be today. It will be later this week.
Okay, well, how about this? I have 9 minutes. Is that what I understand?
You have a little bit, a little bit more time than that, because I got to make sure I have all my jurors, et cetera, but not much.
Okay, then I do need more time, Your Honor, to put, and the problem is I don't know that my expert is available later this week at this point. But let me just briefly get into a couple things. I still don't believe that Mr. Howard has met his threshold requirement of letting us know what fees are actually attributable to the allegedly sanctionable behavior. His client made a counterclaim for ownership of this disputed area. So had the original petition only claimed some sort of declaration of rights under the less than accept language, which the court indicated would mitigate and likely no fee award would be granted, how would he have defended this case any differently? I don't think he would have. I don't think that, I think Ms. Cummings thought she owned that property. I think that's what motivated the trips to the city of Atlanta and the discovery on the city of Atlanta and much of how the case was defended. So I don't believe that we have gotten a clear articulation of what exactly was the problematic behavior that caused his fees to be more than they would have been otherwise, when clearly there was a dispute as to title to this area. Given the time, I'm going to, and the uncertainty of whether Mr. Schneider is available later this week, I'd like to put him on the stand and go through my questions with him. And if the court would grant us additional time, I have another expert witness on the reasonableness of these fees that maybe can be heard at a later time this week.
Okay.
So, Mr. Schneider, Ms. Warner, would you swear him in, please?
Ms. Warner, we can't hear you, so I'm going to swear in the witness. Mr.
Thank you.
Schneider, thank you. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God, sir?
I do.
Thank you, sir. You may lower your hand.
Hey, Jeff, I'm a fast-talking New Yorker, so I'm going to
No
get put to
problem.
the test. Are you
I'm from New
ready?
Jersey, Jeff.
Okay, please state your name for the record.
Jeff Schneider.
Are you a licensed attorney in the state of Georgia?
I am. I was admitted in 1989.
What is your area of practice?
Real estate title litigation.
What is your current role?
Current role in terms of
At the firm that you're at?
Weisman, I'm a shareholder and sort of a founder.
Okay.
Since
How long
1994, yeah.
How long have you been in practice?
Since 1989.
Okay. What is your background in securing marketable title?
I have been major claims counsel for all national title insurance companies that issue policies in the state of Georgia. I have engaged in title clearance work such as this for the last 30 years. I'm the former chairman of the real estate section of the state bar and was on the executive committee for a decade and was just rolled off as a senior advisor to that section. I have served for the last decade on the formal opinion advisory board for the state bar as its real estate representative, which drafts opinions relating to the application of the rules of professional conduct. I've spoken at dozens of real estate seminars locally and statewide governing real property title specific issues. And I serve as a special master in Fulton County, and I'm the owner of a mediation company called Real Property Resolutions, which is just title and real estate specific mediation service.
Okay. Are you familiar with prevailing market rates for legal services of this nature in the Atlanta marketplace?
I sure am.
Okay. Have you previously served as an expert?
I have.
Okay. I've previously submitted your bio into evidence, so I'm going to skip through that step right now.
Ms. Bryant, forgive
yes.
me, let me ask you a quick question. So one, I have no question about Mr. Snyder's ample qualifications to be an expert in this particular arena. But my question is the dispute that I understood the dispute to be that Mr. Howard did the scope of the work he did and not necessarily his hourly rate. Is that accurate or no?
We're not disputing his rate, Your Honor. We're
Okay.
disputing the amount of time that has been spent on.
That's what I thought. I just
Right.
wanted to make sure that I was clear on that. Thank you, Ms.
Yes.
Bryant.
Thank you. Mr. Snyder, have you reviewed the pleadings and the motions filed in this matter?
I have.
Okay. Briefly, what is your opinion of the manner and method in which this lawsuit was initially filed?
Judge.
I'm sorry, was that an objection, Mr. Howard?
Yes, Judge. I understand that Your Honor is comfortable with Mr. Schneider as someone who has expertise in real estate litigation, but I don't think it's been established, and neither has he been admitted as someone who has real estate expertise in this litigation.
Well, I don't know that someone can have expertise in this litigation, but he certainly has real estate expertise, and it sounds like sufficient. Do you want Ms. Bryant to just ask the question and then make the motion so that I can make it official? Is that your objection?
Well, part of my objection is that he has not been admitted as an expert witness in this case. And then the other part of my objection is that if he's going to be admitted as an expert witness in this case, I might like to reserve the right to do some voir dire about that. But maybe we should just let Ms. Bryant ask her questions and then take it up after, if that.
Ms. Bryant, well, why don't we do this? Since everybody is, I think the court had a very different expectation of what this hearing was going to look like than the parties did. And so I apologize if I was unclear or if I didn't adequately allow for time. Ms. Bryant, you mentioned something about Mr. Snyder's schedule. So I have this case, the criminal case I am trying, I expect that will be in the hands of the jury tomorrow. And so I will have the ability to deal with this case and give you an hour or, however much longer it requires. But I think there's a limit on how long this should take, even with unlimited time. So what is Mr. Schneider's availability in terms of trying to do this at a different time by Zoom?
Is that question for me or for Mr. Schneider?
If either one, you can answer
Sure.
for him as your proffered expert, or he can tell me himself.
Yeah, I'm sorry, I don't know his availability specifically, so he'll have to answer it.
Sure. I have a hearing tomorrow morning, which should wrap up by noon. I have a shareholder meeting, which I would love to avoid. Tomorrow afternoon, I'm clear Wednesday and Thursday and Friday of this week. Be glad to make time for this whenever the court's available.
Mr. Howard, what are your thoughts, sir?
Judge, I'm flying to Miami this afternoon for all-day mediation tomorrow. I should be back Wednesday midday. I would think Thursday or Friday I could be available.
So I can definitely accommodate you guys on Thursday morning if that's something that you want. Because here's what I see happening. It's 9:59, and even if I was going to give you a few more minutes, Ms. Bryant has already expressed that she has concerns about the amount of time the court had afforded her, although I do think there's an outer limit on the amount of time this should take. I've got the affidavits, et cetera, but I'm willing to let you make the record that you want to make, number one. Number two, now even that is in jeopardy because Mr. Howard is not, he might want to voir dire the witness regarding his expertise to have opinions about real estate and title and attorney's fees litigation associated with that. And so, or the work at least done in service of it. So it seems as if what we need to do is move this matter to Thursday morning. What does everybody say about that? Thursday morning at 9:30? At which point you would have I can accommodate 2 hours, but if y'all went on for 2 hours, I'd probably be a little bit annoyed, but just being honest.
I
Mr.
have no
Howard,
intention of going on for 2 hours, Your Honor.
Ms. Bryant, again, always a fast talking New Yorker, but also a very fast talking lawyer. So I don't doubt it. Mr. Howard, what are your thoughts, sir?
Judge, my thoughts are just that if we knew what Mr. Schneider's opinion was, we may or may not want to voir dire him, but I have time at 9:30 in the morning on Thursday. That would be fine.
Well, the way this hearing is shaping up, getting Mr. Schneider's opinion might take more than the 5 or 10 more minutes that I have to give you guys. So my apologies. I am going to have Mr. Freehoff issue a notice of continued hearing, and it will be at 9:30 on Thursday, December the 11th. And I appreciate everyone's flexibility and understanding so that the parties can have the time that they believe they need to put on this presentation. Okay?
Thank you,
Thank
Your
you,
Honor.
Judge.
Okay. So as I said, should be getting that here in the next few minutes. Mr. Freehoff will send out that notice. It will also be by Zoom, and I will see you Thursday morning at 9:30.
Sounds
Thank you,
good.
Judge.
Thank you.
Thank you, Your Honor.
Bye-bye.
Just before everyone gets off, are we going to be splitting takedown? Or can you all hear me?
Yes, I can hear you.
Okay.
Mr. Howard, are you splitting takedown?
Let me respond offline once I have a chance to talk to my client about that.
Okay. I guess for
Okay.
now, I requested your services, Ms. Warner, so for now you can send me the invoice, and then I'll wait to hear from Mr. Howard.
Yes, ma'am. Sounds good. I hope everyone has a great Monday.
So here we are, round 2. Thank you all very much for your patience and willingness to pivot to a different day. So Mr. Howard had, at my request, made a very brief general outline of what the issues were when we started the hearing, and then what we had begun to pivot into was to allow Ms. Bryant and Ms. Jett to present in opposition to the attorney's fees. And Ms. Bryant, you had started to call Mr. Snyder, and so I assumed that that is where we would pick up, and then we'll go from there.
Thank you, Your Honor.
Mr. Snyder, if you'll raise your right hand. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You may lower your hand. Go ahead, Ms. Bryant.
Thanks. So good morning, Jeff. Previously, when you were on the stand, well, first state your name for the record, please.
Sure. Jeffrey Hobart Schneider.
Okay. Previously, when you were on the stand, we talked a little bit about your background, so I'm going to go, and that's already in the record. I'm going to go straight to the questions that were pending at the time that the hearing was suspended last week. I had asked you if you had previously served as an expert.
I have.
Okay. And your bio has been submitted into the record of this matter before this hearing. Have you reviewed the pleadings and motions filed in this matter?
I have.
Okay. What is your understanding of the reason why the plaintiff filed this action?
I understand that I've read the petition and the amended petition, and I was not involved in the drafting of it, obviously, but when I reviewed it, I saw it as what I would consider to be really a garden variety title clearance matter brought as a declaratory judgment action by Mr. Jones for purposes of establishing the superiority of title against claims made by Ms. Cummings for adverse possession. And again, it's styled as a petition for declaratory judgment. I noted that it was appropriately brief, 5 pages, and that it relied upon a very limited fact pattern. His assertion was that he had acquired title by virtue of an abandonment ordinance by the city, and that was his basis for asserting title. And then the defendant asserted a counterclaim for adverse possession, which also must have been based upon the abandonment in order to be a viable legal claim. So they They were both relying upon the abandonment from my assessment of the claim.
Okay. And I'm going to ask you a little bit more about Ms. Cummings' pleadings, but I want to ask you one more question as it relates to the petition and the amended petition. Is it customary to assert a claim to title or ownership of property as it's being used in the context of this hearing when you file a declaratory judgment or a quiet title action?
I'm sorry, can you repeat that question?
Yeah. Is it customary to assert a title claim or an ownership claim when you file or when one files a declaratory judgment or a quiet title action?
Right, of course, right. You would set forth the basis for your claim to title, which, okay, as I understood in this case, was that abandonment.
Okay. I want to ask you about a decision. It's State versus SAS Group LLC. The citation is 315 Georgia 893. Are you familiar with this Georgia Supreme Court case?
Unfortunately, yes.
Okay. And do you believe that this case would have been subject to dismissal if it had not been styled as a quiet title action? Once it was amended and the city of Atlanta was added.
Right. The practice has become, as the legislature has changed the rules governing sovereign immunity, it's tricky to sue a municipality or county directly. And so the practice has evolved into bringing, if a municipality or county is brought in, the practice is to do it on a land title issue like this as an in rem action. There are two statutes for the quiet title. One is against the world, and the recipient or the respondent to that is the property. So if you're going to, my practice at least, and I see this among the litigation in my group, is we would assert the claim through that so that it's not subject to dismissal for sovereign immunity reasons by the city. In other words, so it sticks, we use this vehicle, but at least the courts and the appellate courts treat the declaratory judgment and the quiet title statutes interchangeably for purposes of what you want to achieve.
Okay. So you have also reviewed the answer and counterclaim filed by Ms. Cummings, correct?
I have.
Okay. What is your opinion about the defense's strategy and claims as it relates to the abandonment?
In my experience, it's really common in these cases where one party asserts a claim, especially when you see here where there was some pre-suit exchange back and forth. I own it, and then she says, well, she owns it. But her assertion was that she owned a claim by adverse possession. And as I understood her answer and defenses, she really asserted primarily, or was litigated primarily, the issues of the plaintiff's claim to title, and also the claim that that she relies upon an argument based upon some language in the back chain of her title that says that her claim was, oh, let me back up. Okay. So she asserted a claim for adverse possession as a counterclaim, in response to which the plaintiff asserted that she was never entitled to that alleyway area, that if she reviewed her chain of title, which was all of 2 links, which makes this case easy. This is like a 4-deed, 1-2 witness case. She would see that when she received title, that she did not, her property description did not include the Schuler alleyway, that was, and there was expressly a less and accept provision in there saying we're giving you this property. I think it was 1085 was the street number, and less and accept any rights that you may claim under the Schuler Avenue property, the alleyway. And that was given by Jones to Cummings' predecessor, and then was in the chain of title to Ms. Cummings. But they asserted, as I understood it, that that language was somehow legally unenforceable due to restraints on alienation and various theories concerning covenant expiration, etc.
Okay. Is that a valid legal position in your mind?
No, that's word salad. That language is commonly used. If I had to guess, in all the title reports that are sitting on my desk, probably 1 in 5 of them, deeds has less than accept language. All that says is that it clarifies that you may be getting green acre, but you're not getting any of yellow acre, or you may be getting the house, but you are not getting the pool. It makes very clear that that would be excluded. It's never been considered, in my experience, a covenant or restraint on alienation. I'm not aware of any case law that says that a less than accept reference in a deed would be interpreted that way. I'm not aware, as a matter of practice, that that's ever been treated as an encumbrance on title. If nothing else, it's being abundantly clear what you own and what you're not owning. It's not a covenant. It's an exclusion. Yeah.
So, with respect to Ms. Cummings' counterclaim for ownership, if the city of Atlanta were deemed to have been the owner of that property, would she have been able to sustain a claim for adverse possession against the disputed property?
Of course not. That's why I said earlier that both parties are relying upon the validity of this covenant, or I'm sorry, of the abandonment. Obviously, Jones is relying upon it because that's his vesting deed. I know Mr. Howard, in his opening remarks the other day, said that, I find my note on it, but it was a false claim of ownership. And that suggested to me that he believed that in order to prove legal title to the property or equitable title, that you'd have to have a deed. And that's really never, that's a very layman's interpretation of rights to ownership. In this case, the abandonment document itself was the vesting instrument. A deed in and of itself is not necessary in order to establish it, as the defendant would recognize. I mean, she has no deed to it. She's rolling strictly on possession. But they both can assert these in these actions. It's the reason the declaratory judgment process or quiet title process exists. It's a title clearinghouse for people arguing over competing claims. So I may have answered more.
But narrowly, why could Ms. Cummings not sustain a claim for adverse possession against the city of Atlanta?
Right, because you can't adversely possess against the city of Atlanta. So if the abandonment was valid, as Mr. Jones advocated, then she could try to adversely possess against him, a private individual. But if it's invalid, this is why I was a little confused by their strategy in this case, because on the one hand, they're saying, Jones, your abandonment is not valid and you have no title, thus it must be still the city's. And on her counterclaim, she's asserting that, it's of course valid because otherwise I couldn't own adverse to the king, not uncommon types of inconsistencies in these kinds of pleadings, but she would have to necessarily require on the validity of the abandonment. That's why I couldn't reconcile her counterclaim with the Jones claim.
Okay. So in order for her to actually sustain a claim, she would have had to have believed that the abandonment was done correctly.
I don't know what she would have believed, but the law would have presumed to be the case. Yeah.
Okay. I want to shift a little bit to some of the billing entries that were filed and attached to the affidavit of Bo Howard.
Yeah.
Have you reviewed these billing entries?
I have.
Okay. What is your opinion of the time spent on tasks throughout the life of this litigation?
Candidly, profoundly excessive, considering the simplicity of this case. This is what I would call a two-man parade. You've got no depositions. You've got maybe 4 deeds. You've got a pretty simple abandonment ordinance, and in my opinion, very simple case law to interpret. You don't need to spend 20 hours searching the effect of abandonment when there's plenty of cases on point on this. The effect of an abandonment is the adjoining property owners are vested with title up to the center point, and then they owe each other reciprocal easements so that they can walk over each other's land. So in terms of the lesson accept, I saw that as a fishing expedition that ended up with no fish, because the reality is that that language is so commonly used to exclude property that they made some academic arguments that aren't supported by the law. And I saw that, frankly, over and over. I saw that there were 3 lawyers assigned to this case, 2 of whom had no real estate experience, 1 of whom was admitted in the same year this case was filed. The other one was admitted 2 years prior and spent some time as a law clerk, but didn't appear to have any real estate knowledge whatsoever. Mr. Howard is obviously very well educated, I'm sure a great lawyer, but it seemed that they spent an exorbitant amount of time researching obvious issues in a case where the facts were extremely limited, in my opinion.
Okay. Throughout your career and in your role right now, do you frequently provide budgets or estimates to clients for how much litigation might cost when they bring a case to you?
Sadly, some clients, such as title insurance companies, require it to provide a budget through dispositive motions. So yeah, I routinely do that. And when I serve as a special master, I also consider fees that are charged by parties.
Okay.
And so yeah, the answer is yes.
Okay. Putting aside whether you thought the strategy was sound or the way the case was defended is the way you would have done it. If you were preparing a budget for the types of tasks that you saw billed, can you give me an estimate of what those would have been?
Sure. I mean, I have the benefit of looking at hindsight. So in all fairness to all parties, I'm not looking into the future, but looking into the past. But when I look at a 5-page complaint, even on an off day, it'd probably take me an hour to look at that. In this one, you had really 1 deed, or maybe 3 deeds to look at, and a simple ordinance. And so, it would take me an hour. In terms of looking at this, drafting an answer, I assume that I would interview my client who would tell me, and in this case, if I recall, the defendant's counterclaim was based upon a fence that was put there before she purchased the property. So an adverse possession claim, which is pretty simply set out. But I had an estimate 3 hours for that.
Okay.
Especially given that this is a very limited number of complaint, filing an answer to it would be pretty simple. Investigating the facts, I would apply 5 hours, which in this case would, you could examine title online. I just, as an exercise, got on GSECCA to just check down title this morning. And granted, I've been doing this a long time, but we're really talking about reviewing less than half a dozen instruments. So I put 5 hours down for that, which I think would give rise to calling whoever you might want to call, etc. There was only limited written discovery in this case, and the productions were pretty nominal by comparison to most cases. This is not, the Young Thug case with RICO claims and thousands upon thousands of boxes. So the paper discovery I put together would be maybe 5 hours if you really wanted to charge. I think there were maybe 3 or 4 party and non-party interrogatories, RPDs sent out by the defendant. I'm not sure that the plaintiff served any, and surprisingly, nobody was ever posed. I considered the motion to join the city at 5 hours, which frankly, if the city really needed to be joined, would be pretty rudimentary. And in this case, as I understood it, the plaintiff prepared all the pleadings concerning that. But just for sake of, if I had to do it, maybe 5 hours, because it's relatively simple assertion. The review of the records that were produced, you know, they were extremely limited, and there weren't documents that would be hard to find. Maybe you were looking at the ordinance and the various terms of securing a deed. There wasn't any substantial document production from what I could tell. So reviewing those documents, a couple of hours. The motion to dismiss, I would allocate I would not have advocated this motion to dismiss or the renewed motion to dismiss. I think for the reasons I've already said, that the less and accept argument just doesn't seem to be, that just seems to be somewhat imagined, and the plaintiff's claimed title would appear to be based upon case law and the ordinance itself. But I allocated 5 hours to that, and a miscellaneous of 5 hours, maybe for the lawyers to talk or meet, hopefully to try to resolve the case. And again, this is just looking at the skeleton of this case, but I came up with maybe 33 hours on that, which at $5.95 an hour. And I don't dispute Mr. Howard's rate. I'm sure he bills higher than that on many cases that he's involved in. But that came out to roughly 20 grand as being sort of for the bare bones of this case. In looking at the motion for attorney's fees without judging the merits of that, but just simply if I had to put together a motion for attorney's fees, I would consider the facts that were in evidence, the known law concerning supporting the less and accept provision, and you know, I'm looking at maybe 10 hours because in having done the motion to dismiss, I would have already done all of that research. So I'm not coming up with new law or new facts. I'm just simply organizing those facts to say that based upon what the record reflected, that would be a number. I would take 2 hours to remind myself of the facts. I would take an hour and a half or so to plug in the law, and I would do some drafting and come up with that amount of time. Again, not suggesting that one side or the other should have or could have won on those, but just what would that physically take. And the difficult part for me in assessing the fees was the absence of any order prevailing on any of the underlying merits. You know, in this case, you had the declaratory judgment and quiet title statutes performing as they were intended. A claims they own property by virtue of this city action. B says they own by possession. They disagree. They're welcome to do that. One's relying upon an instrument everyone on this face could study. The other one is looking at a fence and saying, okay, the fence is there. That sometimes gives rise to adverse possession. Let's have it out. What's unique about this case is that the city gets involved, a deed gets issued, that resolves the city. They come in and out of the case. The plaintiff, in my review, didn't instigate adding the city and expanding the litigation. I think what they wanted to do was just keep it between the two neighbors, which they would have the right to do. Once you took the detail with the city, all the dominoes began to fall. So then you had the lender go out, then you had Jones' partner or the other party come in and out, and then you had a dismissal of all parties at the end of the case. So in terms of pointing a finger for purposes of fees, I don't see that the defendant prevailed on any of the meritorious defenses, and by all accounts seem to have abandoned their counterclaim. I'm not saying that there are merits to it or not. I'm just saying that this case epitomizes when this process works well, and was intended to the outcome. One party wasn't scorned at the end because of the adjudication, thus giving rise typically to attorney's fees. I know I'm getting beyond testimony and more argument, but in the hundreds of these cases I've been involved with, especially where the city of Atlanta enters, this ended very quickly. And it was a very simple series of events that left Jones able to dispose of the property with marketable title, and there being no further advocacy of the counterclaim. I mean, as sad as it is, in my world, that's a success. But in terms of the overall fees, to answer your question, I found the fees on a 5-document, no deposition, maybe 3-witness case to be multiple times what it ordinarily would be.
Okay. I have no further questions for Mr. Schneider. However, if Mr. Howard wants to ask him questions, I would like to have an opportunity to maybe ask him 1 or 2 questions after that.
Of course. Mr. Howard, questions for this witness?
Yes, Judge. Mr. Schneider, good morning. I don't believe we've ever met before, correct?
We have not.
Well, it's a pleasure to meet you. I'm sorry.
I have the same poster that you have right over your shoulder at my house.
Did you get it from Yeehaw Industrial Letterpress outside of Knoxville, Tennessee?
I think I did. Yeah.
Those guys taught a seminar at my college. I was fortunate enough to be there. Anyway, that's interesting. I'll look forward to getting to know you at some point. But are you being paid for your testimony here today?
I'm not.
Okay. Then why are you? Well, who asked you to provide this testimony?
Ellie Jett and John Robinson asked me to take a look at this case.
And are you? I assume you have a professional relationship with them that dates back some time.
I've known John for a long time. He has served as a special master in quiet title cases in DeKalb County, where I've been an advocate. And as he might say, he ruled against me more than a few times. So, but I've known him for a long time, and I've run into him at conferences. But Allie Jett used to be with my firm, so I knew Allie, and she worked in my title litigation group.
Understood. Are you friendly with them outside of your professional relationship?
Occasionally. Allie I run into with Real Property Institute, and John, we're not social. We don't go out. We're not what I consider to be social friends, but.
Understood. How many hours total did you spend preparing for this hearing? I guess including any time that you spent reviewing my invoices and drafting and finalizing your affidavit?
I've probably spent 10 to 15 hours.
Okay. And so you're not billing anyone for that time?
I'm not.
Okay. What is the specific question you were asked to give an expert opinion in response to?
Let me see if I can remember that. I was asked to look at the complaint and the defenses that were asserted in the context of a claim for attorney's fees, as to the reasonableness of the litigation strategy, the merits of the responses and defenses, and then the reasonableness of the fees that were being claimed by Ms. Cummings.
When you say the reasonableness of the litigation strategy, do you mean Mr. Robinson's litigation strategy?
Both sides, really. I was trying to take an objective view of it.
And do you view part of your role here today as to advocate that an attorney's fees award, in fact, should not be appropriate in this case?
That's my opinion. I'm not taking, I mean, I know that it may not look like it, but I'm not advocating for one side or the other. I'm just sharing my 30,000-foot view of, in the context of my experience, the nature of claims and why you would bring a deck action and what defenses are asserted to those, and then in turn the fees that are driven by these.
How many times have you testified as an expert witness on this particular question?
On the question of reasonableness of fees?
Yes, sir.
I think about 3 or 4.
How many of those times did you testify on behalf of the party that was seeking fees?
Other than in cases where I was the plaintiff, where I was the movant, but as an expert, I can't honestly remember. I know I have responded to, I know I have testified at least in court twice as to the reasonableness of other people's fees. And I think in one case it was, I believe the fees to be excessive or not related to the issues in the case. And the other, I may have just been the expert witness setting out the fees.
So that would be 2 of the 4 times you testified on behalf of the party that was, as an expert on behalf of the party that was seeking fees. Did I understand that correctly?
I'm just saying that what I can recall about the testimony was that on one, I was particularly retained to review what the client believed were excessive fees, and the other was me setting forth a basis for fees in a case on behalf of the party that was seeking them.
So in the matter where you were, were you ever retained as an expert to testify in a matter where you were opposing the fee award and you opined that the fee award was in fact reasonable?
Probably not. Yeah.
How about the other way around? Were you ever retained as an expert witness to opine in favor of an award of fees, and your expert opinion was in fact the fee award was the fees requested were not reasonable?
No, obviously not.
Did you draft the affidavit that was, I believe, I'm sorry, let me just refresh my recollection. I believe you signed an affidavit in this case, correct?
I did not, no.
Okay, excuse me. Did you have any sort of expert report prepared in this case, whether it was produced or not?
I did not.
Okay. Sorry, I'm scrolling through the list of questions that I had that you've already answered.
Okay.
Do you have any professional relationship with Mr. Kellum or his company, Kelco?
I've never heard of them, no.
Fair enough. How about Brian Henderson, the attorney at Gilmet Pulver?
I know his name, but I don't have any relationship with him.
Have you ever met Ms. Cummings?
I have not.
Okay. I assume you agree an expert's role is to be objective and not advocate for either side, right?
I agree with that.
Okay. Has anyone asked you to advocate for Mr. Robinson or Ms. Jones in this case?
No, but I assume they wouldn't call me if they didn't believe my position would help them. But no, I don't have any vested interest in this. I'm looking at it strictly as I would not have gotten involved if I didn't believe in my opinion.
I can appreciate that. Your theory in this case, though, is would you say it's developed specifically for litigation purposes? You would have no reason to. Oh, never mind. I just retract the question. It doesn't matter. Do you know whether Ms. Cummings had alleged adverse possession prior to being sued?
I can't say with any degree of certainty. I think there may have been an exchange back and forth at some point, but I don't remember the context of it. But I know she asserted that in the counterclaim.
Is it possible to plead adverse possession in the alternative, meaning I don't believe you own this property, but if you do own this property since the date when you claimed you own it, I've had my fence here for the whole prescriptive period?
I mean, you can argue that. I don't know that it was pled in the alternative, but in this case, and I'd have to reread her answer on that, but it seems fairly unambiguous that that was her position. And I believe that, honestly, to the extent when she learned of the lesson accept language, in other words, that it wasn't in her deed, I mean, she may have had then maybe an argument with the seller. Hey, I thought you sold this to me and you showed the fence to me. That might be her remedy, but for whatever reason, she pled this in the affirmative and sought relief.
Well, did you review the transcript of the first motion to dismiss hearing in this case?
I have not.
Or has anyone made you aware that during the first motion to dismiss hearing, there was a discussion about whether or not it was possible to adversely possess Schuyler Avenue from the city of Atlanta?
I haven't reviewed it. Yeah.
So then you're not aware that during that hearing, Ms. Cummings, through me, took the position that the adverse possession question was from that point forward to be construed in the alternative, meaning news to us, you couldn't adversely possess from the city of Atlanta, but he has been claiming that he owns this property. And so therefore, if he does, she's adversely possessed it. And that was our position. You're not aware that that was brought to the court's attention during that hearing?
Well, I read the pleadings, and the pleadings affirmatively seek title. So I'd go with the pleadings rather than colloquy.
No, I understand. But so your answer to the question is you don't know what was said during that first hearing, correct?
I know what was in the pleadings. So correct. I wasn't privy to that.
No, that's fair. Did you speak to any witnesses from this case?
I have not spoken to anyone that I don't know who the witnesses were in this case. I didn't understand there were any hearings of taking live evidence, but no.
Perhaps it was a bad question. Did you interview anyone did you interview anyone that you would consider to potentially be a witness in this case?
No, I mean, I've spoke briefly with John Robinson and counsel, but I don't foresee they were witnesses.
Would you agree with me that you're not necessarily aware? Well, we've never spoken about this case, correct?
We have not, right?
Okay. And so would you agree with me that John Robinson coming into this case probably had different information than I had available to me about the facts and circumstances?
It's the case in every case. I assume counsel have different information and they ferret it out from each other. So, yeah.
So if I said that you would be unfamiliar with the information holes that we were facing coming into this case, would that be a fair statement?
I don't know what you mean by information holes.
That's a fair request for clarification. For example, Mr. Jones was claiming that he was the legal and equitable title holder to the property. And one of the questions that we had was, have you in fact received a deed in Atlanta? And are you aware of whether or not we had any difficulty getting an answer to that question?
I don't know. I didn't see that you'd ever taken his deposition, so I don't know what his testimony would have been or your level of inquiry would have been. I don't know that it made any difference in terms of the merits of his position, because the abandonment itself vested title irrespective of whether a quitclaim deed was executed or not. And secondarily, I understood that you met with John Robinson, and I'm sure he was candid with you about where the status of all that was. I don't know that for a fact, but John has a lot of integrity, and I'd be surprised if he would not have shared that with you. I didn't therefore understand, the lengths to which time was billed trying to find out the obvious.
Did you read the correspondence between me and Mr. Robinson?
Only what's in the record of the case.
So if I had sent an email to Mr. Robinson asking a direct question about whether a quitclaim deed had been issued, you would not know whether I got a direct response to that question?
Of course not, no, if I didn't.
Do you know which, are you aware of the role that J.D. Kellum and his company Kelco played in this case?
Not other than what the pleadings reflect.
So you read Mr. Kelco's motion to intervene in his cross-claim?
I did.
Okay. And so you're aware that Mr. Robinson had agreed to sell the Schuyler Avenue property to Mr. Kellum's company, correct?
No, I think Mr. Jones did.
I think you're right, but okay, I apologize. I said the wrong name. But, and you're aware that Mr. Jones was in default of his obligation to deliver that property and to repay the amount that he borrowed from Mr. Kellum?
I don't know whether, I know what was in the pleadings. I don't know the underlying matter. Again, surprisingly, there were no depositions in this case, so I can't tell what anyone would testify to.
Did you review the deal paperwork between Mr. Jones and Mr. Kellum, including the purchase and sale agreement, the promissory note, and those other documents?
I did not.
Okay. Do you have any idea whether Mr. Kellum was cooperative with me or uncooperative when I tried to question him about the facts of this case?
I would have no idea. I mean, and nor do I believe it's relevant to the pending claim for fees. I mean, in this case, the plaintiff is Jones, and he's asserting a claim under the abandonment, and ultimately was successful in conveying title out and then turned down the chain of title. So whether they had an agreement or not doesn't bear upon the plaintiff's right to proceed with this case.
Are you aware of whether the city of Atlanta was cooperative or uncooperative with me when I asked them questions about who was the actual owner of the Schuyler Avenue property as of the date of the litigation?
I wouldn't be unsurprised if it took you a bit of effort to do that, just having litigated with the city of Atlanta many, many times. But what did stand out to me was how promptly the city capitulated and executed a deed. And what stands out to me particularly is Patrice.
I'll object to the relevance. I'm sorry, the question was about whether or not you knew whether they were cooperative with me in my request for discovery, not an opportunity to advocate for their behavior with respect to the deed.
I understand your point, Mr. Howard, but I'm going to let Mr. Schneider answer the question. I will say, as we're all taking a breather and I'm talking for a moment, I will say most of what's being discussed right now are facts and information that were provided to the court that the court took into account in its decision to say that it would consider an awarding and that it would award an amount of fees. And I understand that this information is still relevant to the issue of why, from Mr. Howard's perspective, why the fees are as high as they are, and for Mr. Schneider, or more correctly, Ms. Jett and Ms. Bryant's perspective, why the fees are too high. And so I'm still allowing this sort of ongoing conversation, but I think we're going a little farther into the weeds than we actually need to go, because most of this information the court is already aware of and had taken into account in determining that 91514B fees might be appropriate against Mr. Jones. So with that, Mr. Schneider, you may answer the question.
Now I've forgotten the question. So.
That was my intent, but
yeah, no, well done.
The question, Mr. Schneider, was, are you aware one way or another whether the city of Atlanta was cooperative in responding to my question concerning whether they owned the Schuyler Avenue property at various times during this case?
Yeah, that I'm not privy to that, but from the conduct in the case, it's suggested that they came to the table almost immediately when they were made a party, and Patrice coordinated that. Patrice Perkins Hooker, the city attorney, who I know quite well, stepped in, delivered the deed, and that suggested that they were cooperative once they were brought to the bar.
I'll have some questions about that in just a minute, but are you aware that there was a different city attorney when this case started?
Of course, yeah.
Have you ever met or spoken with Miss Ashley Vanderland?
I've spoken with her many times. She used to work for me.
Did you speak with her in the context of this case?
I have not, no. I talked to her brother recently. He lives in Montana, and it's a good person to know, but no, I have not.
Okay. Does it shock you for me to tell you that Miss Vanderland was the person with whom I was corresponding about my discovery request with the city, and that when she left employ with the city, there was no out of office message, no communication, and no other indication to me that she was gone? My emails were simply going into a black hole.
I can't answer that. I'm not sure I know the answer to that question, how they do their out of office. But that may have been your experience. I don't know.
Would it surprise you to learn that I had to physically visit the city attorney's office in order to find a secretary who could tell me who actually would be counsel in the case that could produce documents in response to my request for production on which the city was overdue?
I'm surprised that you wasted time doing that. That's what discovery is for.
You're surprised that I could not get somebody on the telephone at the city of Atlanta to tell me who was the attorney to produce documents?
I'm surprised that you wouldn't follow what would be a 0.5 billing entry to send an RPD and a FOIA to the city, which you did send a FOIA to the city. So I don't know why you would waste your time doing that and bill 4 hours to your client. When there's
Are you aware that I could not get anyone in any department, the city of Atlanta, to take a position concerning whether or not they owned the Schuyler Avenue property?
I'm not aware what you did to achieve that, so I can't comment on that.
Did you speak with the city of Atlanta's appraiser, David Ball?
I'm not.
Have you reviewed Mr. Ball's appraisal that he provided to the city of Atlanta in connection with Schuyler Avenue?
I have not.
Did you review Mr. Jones's privilege log in this case?
I have not.
Did you review Mr. Jones's document production in this case? By which I mean, did you read every document that he produced?
No,
Have you seen Mr. Jones's document production in this case?
I have not.
You characterized the document production earlier as being pretty minor, not much of substance produced. Are you aware that Mr. Jones withheld his document production until after the quitclaim deed was issued?
I'm not privy to any of that.
Would it surprise you to know that, well, you haven't seen the document production. Have you reviewed Ms. Cummings' correspondence with the city of Atlanta related to this case, particularly her correspondence with Bashan Mann?
No, I have not.
Has anyone made you privy to what the city of Atlanta was telling Ms. Cummings about how she might obtain title to half of Schuyler Avenue in this case?
I'm not familiar with that, nor that she took any effort to do that.
So you're not familiar with the fact that the city of Atlanta and Mr. Jones, through Mr. Robinson, sent Ms. Cummings a document asking her to check a box stating whether she would like to purchase half of Schuyler Avenue?
I'm not.
Are you aware of whether the city of Atlanta city attorney office had taken the position that the abandonment in 1994 was legally ineffective?
Apparently not. They executed a quitclaim deed.
Are you aware of whether they ever took that position during the course of this case?
Not from reading. My review of the pleadings don't suggest that.
But again, you didn't read Mr. Jones's document production, correct?
I have not.
Are you aware of whether the city of Atlanta was telling Ms. Cummings that if she would follow the abandonment procedures, she could obtain through abandonment half of the Schuyler Avenue property from the city of Atlanta?
I would be surprised if that were true, given the title records that are part of this case.
So you're not aware that they told her that?
I wouldn't have any reason to know one way or the other.
Okay. Are you aware that until the very end of this case, the city of Atlanta was telling, well, I've already asked that. Let me see if I can skip down my list of questions. I think you've answered some of these. Have you reviewed the city of Atlanta's document production in this case?
Have not.
Have you, were you privy to any of my communications with City of Atlanta Attorney Alexander Hamilton concerning which documents the city was withholding from production?
I have not.
Do you have any basis to know that the City of Atlanta, through Mr. Hamilton, told me that it would not be producing documents that were exchanged between the city and Mr. Jones related to his desire to purchase the Schuyler Avenue property because they were, quote, confidential and privileged?
I didn't see that, nor did I see you file a motion to compel.
Okay, so you were not aware that they took that position?
I have no reason, as I sit here, to believe that.
Are you aware that the city of Atlanta did not produce documents with their FOIA showing how they ultimately got to the agreement with Mr. Jones to issue the quitclaim deed?
I didn't see the FOIA request. I saw some time entries where you were following up with them.
Did you review my request for third-party request for production of documents to the city of Atlanta?
Very briefly, yeah.
Did you review any response to that?
I did not.
Did you review Mr. Jones's bills from Mr. Robinson in this case?
I reviewed the total amount, but I didn't study them. I wasn't hired to advocate or opine as to the reasonableness of their fees.
Do you know what the total amount of fees charged to Mr. Robinson in this case by to Mr. Jones in this case by Mr. Robinson and Ms. Jett are?
I don't offhand.
Do you believe that those fees that they charged were unreasonable?
I don't have an opinion of that one way or the other.
Did you spend any time comparing Mr. Robinson's bills to his document production or his privilege log?
I have not.
So then you're not aware that Mr. Robinson and his firm billed Mr. Jones for written correspondence with the city that would have been responsive to my document requests.
I have no idea on that. I'm not, I'm not privy to any of that.
So you're not, so then you're not aware that Mr. Robinson and his firm withheld documents from production and did not log them on their privilege log. And the first time that I received notice that those documents existed were when I saw his attorney's fees bills in this case.
I'm not familiar with any of that. I haven't been asked to have an opinion or review that.
Did you do any analysis of the total number of hours that my firm spent sending written discovery requests and following up on those requests to the city of Atlanta?
I have reviewed all of your time entries.
How many hours did I spend sending written discovery requests to the city of Atlanta? Do you know?
I can determine that if you want to give me some time, or if you want to tell me.
It's in the record. Do you think that I overbilled the amount of time that I spent sending discovery requests to the city of Atlanta and following up on them?
I think there are a lot of things that were done on this billing that were excessive.
I'm asking about the city of Atlanta entry specifically.
Not specifically with the city of Atlanta.
Do you do any analysis of the total number of hours that my firm spent sending discovery requests and following up on them to Mr. Jones?
I'm sorry, can you repeat that?
Did you do any analysis of the total number of hours that my firm spent sending discovery requests and following up on them to Mr. Jones?
I have reviewed those, yeah.
Did you review the good faith correspondence that I had to send to Mr. Jones specifically?
I have not.
Are you taking the position that I didn't actually work the hours that appear on my bills?
My opinion is that if you worked those hours, they were grossly excessive given the simplicity of the subject matter of this case.
No, I understand that that's your opinion. You said it like very clearly, but I'm asking you, is it your opinion that I did not actually do the work that's reflected on the bills?
I mean, my candid opinion is you couldn't have spent that much time given the relative simplicity of some of these tasks, and you were billing for things that clearly were not billable. Would you like an example?
Not yet. Did you do any analysis of the total number of hours that my firm spent sending written discovery requests and following up on those requests to Mr. Kellum?
I don't have the total tab of those, but I did review that.
Okay, and by how much time do you think I overbilled for my time trying to gather facts from Mr. Kellum?
Well, from Mr. Kellum, I have no idea. I mean, some of the time entries were very general.
That's fine. Did you do any analysis of the total number of hours that my firm spent communicating with the city of Atlanta appraiser concerning his appraisal report and what it shows concerning the ownership of Schuyler Avenue?
Your time entries weren't that specific.
Okay. So you don't know how many hours I spent on that?
I couldn't figure it out from what you sent to your client to bill her.
Do you have any basis to claim then that those hours were unreasonable or excessive?
As I've told you, I believe that the time entries were, you may have spent the time, but it is not a reasonable period of time. And there were things for which you billed her that are categorically not billable, such as adding a certificate of service. You know, there's a number of things like attaching certificate of service to both documents, 0.4 hours, arrange for both documents to be filed, 0.5 hours, send courtesy copies to opposing counsel. And then review docket, determine status of filings, speak with Fulton County Clerk's Office to determine that the filings are still in process. 0.6 hours, review and revise motion numerous times. But you were billing for administrative tasks throughout this process. And I'm glad to go through them in detail. And there were mostly your two associates that were doing this, but it seemed like a billing frenzy.
And did you have a sum of the total number of administrative tasks that you believe should be excluded from the total?
Sure, I can go through those with you.
Well, let me save you the trouble.
Okay.
And let me say this. So I think all of you know that before I was a judge, I was a civil litigation attorney for about 20 years. And I did billing budgets for corporate clients, and I routinely billed and I routinely reviewed bills. And so I believe that not only my personal experience, but also the law supports the position that a judge is an expert of what is reasonable and what is not reasonable billing time. And I am quite capable of and fully intend to review bills and exclude matters that might be considered administrative in nature and that would not typically be billed for, or for which time billed for an action might be excessive. And so I don't think that we need to spend our time focusing on those matters.
Understood, Judge. Thank you very much. I have a few more questions then.
Go ahead.
Mr. Schneider, did you review Mr. Jones's, either of Mr. Jones's 44220 affidavits?
I don't think I have.
So you were not asked to, have you reviewed the contract that Mr. Jones executed with the city of Atlanta a couple of years prior to this litigation, by which he agreed to purchase the Schuyler Avenue property?
I did.
And so you're not aware of the statements that he made about that contract and filed in the public real property records?
Oh, you're talking about the affidavit of title? Right.
It was described as a 44220 affidavit by Mr. Robbins.
That's what I mean. Right. Yes.
You did review the affidavit?
I did.
Okay. Did you review his second 44220 affidavit that he filed in the top chain of title?
I can't picture it in my mind at the moment, but I did review his affidavit of title.
Are you aware that at some point in this litigation, Mr. Jones filed an amended petition stating that the city of Atlanta owned Schuyler Avenue up until the time that it executed the quitclaim deed to him?
That may have been his position. You'd have to show me the document to get me to give it a yes or no on that.
Would you agree that if that was his position, that would be a binding judicial admission?
Well, you're asking whether if he had any legal or equitable interest in the property prior to the delivery of the deed. I would say
that's not my question, respectfully.
Okay. Then let me hear your question again.
My question is would you agree that if Mr. Jones took the position in a petition that he filed with the court that up until the date he was issued the quitclaim deed, the city of Atlanta owned the Schuyler Avenue property, that would be a binding judicial admission?
Not necessarily. It would depend on what else is in the record. I mean, upon the execution of the agreement, which was executed, he had equitable rights to that property, enforceable by specific performance action or otherwise. But he could then assert a claim against the city to establish title under that executory contract. That's pretty black letter law.
Do you know what the contract states about the date when ownership of the property would change?
I don't. I assume you're going to tell me it's the date of the delivery of the quitclaim deed.
That's what it says. So you're not aware of that, though, correct?
I can't recall. I'm not trying to be evasive with you, but I just haven't committed I'm not as familiar with these documents as you all are.
Are you familiar with any of the conditions precedent to the transfer of the quitclaim deed that are stated in that contract?
I am generally, right.
And what do they say?
Well, I understand that generally it requires the tender of the purchase money, which I understood that Mr. Robinson went to great lengths to perfect, including trying to deliver certified funds to the city. And he may have found what you found, which is the city is not the most available municipality that he's ever dealt with, even when it comes to taking someone's money. So, did he tender it? Yes, that's my understanding. And satisfied that condition, which usually the buyer's only condition is the delivery of the money. But I think he may have found what you found, which was, it's duck, duck, goose down in City Hall, trying to find somebody that's actually the one that will satisfy that.
Did you read Mr. Jones's motion for attorney's fees against Ms. Cummings and all the supporting documentation and case law?
I did. I didn't spend a lot of time with that because I wasn't really asked to have an opinion of that.
Are you aware that his motion was denied?
I am.
Okay. Did you read Ms. Cummings' response to Mr. Jones's motion for attorney's fees and all the supporting documentation and case law?
I did not.
Are you aware of how the court, well, I already asked that. Did you read Ms. Cummings' motion for attorney's fees against Mr. Jones and Robinson and all the supporting documentation and case law?
I did.
You read all of the supporting documentation that was attached to the motion?
I did at some point. I mean, I focused mostly on your brief.
How would you describe the exhibits?
I would describe them as spending time on things that weren't related to the merits of the case. And as I understood it, the position you were trying to take throughout this case was this lesson accept argument, that she wasn't bound by that, or that the lesson accept argument was not, lesson accept provision was not an enforceable agreement. And that, that was a primary focus on that. And also your position that the city had not conveyed legal or equitable title to Jones at the time of the action was commenced, but I disagree with that by operation of a binding contract.
The contract between Jones and the city of Atlanta, you believe gave him title to the property?
He used the word title pretty loosely. Did it give him legal rights to the property? Absolutely.
Okay, I'm sorry. I just used the word title because that's the word that you used, but I understand your position.
Yeah.
Could you tell me what volume of attachments there were to the motion for attorney's fees by Ms. Cummings?
I didn't weigh them, but they were a lot of documents that were communications between the parties and maybe communications between you and Mr. Robinson. But to me, they were somewhat evasive of the merits of the defense in the case, which were pretty simple.
And you believe that many of them related to the lesson accept issue?
Well, I tried.
That's what you testified, so I'm asking your basis for that.
I tried to follow your logic in the motion because really it complicated an otherwise overly simple dispute. Did he have a right to bring the action? And by the time you filed your motion, he very well did, even under your own definition. He had a deed in hand and he followed the court's direction to join the city and achieve that. Thereafter, you really lost any right to pursue fees, in my opinion, that could stand. I mean, the city's position was rendered finite.
Did you do any analysis of how many hours my firm spent drafting Ms. Cummings' motion for fees?
I did.
And do you know how many hours and how much money was spent on that?
I know how much hours. I don't know whether she's ever spent any money.
Well, how many fees she incurred? Let me ask it that way.
Yeah, I understood that there were roughly, I think, 64 hours spent in the preparation of the motion, if I'm not wrong.
Are you getting that from my email that I sent last night?
I may have, yeah, and I think it may have coincided with my calculation as well, but I admit I'm not a mathematician, so.
Do you have any reason to doubt the numbers that I sent to the court last night when I put the various tasks into those 4 buckets?
That was roughly the number I came up with.
Okay. Did you do any scientific analysis or statistical analysis of, I tell you what, I'm not going to ask these questions because I agree with the judge that she's an expert on determining what's a reasonable amount of time. So Did you build any sort of spreadsheet or did any other kind of technical analysis of my invoices?
Nothing that formal. I've just made a chart, and I was looking at your thing. I didn't see that last night, but I saw it this morning, and you've broken down like roughly 45 hours on the lesson accept argument, and then 118 on the false ownership argument. Your 91514 had 63.95. And, you know, I've given you my assessment of my opinion on those overall hours.
I appreciate it. Do you agree that when a party takes a position in a case that is later disproven as a matter of fact, that it's reasonable to conduct written discovery? It's reasonable for the opposing attorney to have conducted written discovery and to interview relevant witnesses and parties? I asked that question poorly. Let me withdraw it. Let me ask you a different question. Do you agree that when a party takes a position that your opponent takes a position that you disagree with, that it's reasonable for an attorney to conduct written discovery and to interview relevant witnesses to try and disprove that position as a matter of fact?
It depends on the facts of the case. I mean, and whether those time expended is reasonable or not is the issue here, not whether you had the need to do that.
I wasn't asking a question about the total number of hours. I was just asking, generally speaking, do you agree that an attorney behaves reasonably when he conducts written discovery and interviews witnesses in connection with the disputed fact?
Well, that's part of our job, yeah.
Okay. I'm sorry, I'm trying to cut to the end of my list here because I think you've answered a number of my questions that I had prepared to ask. Prior to the initiation of this litigation, what is your opinion concerning whether the city of Atlanta had complied with its contractual obligations to Mr. Jones regarding the sale of Schuyler Avenue?
I don't know enough facts, quite candidly, to make a determination. I mean, from what limited amount I understand, they were not acting promptly, and that wouldn't surprise me. But
so you could not opine one way or another whether the city of Atlanta should have already sold him the property before he started this litigation?
Well, I think I won't use the word sold, but I do think that they should have delivered that. I mean, in my own opinion, it didn't seem to be there was no, what I could tell, any reasonable basis for them to delay doing it.
Did the city of Atlanta have a reasonable or legal basis to ask Mr. Jones to give Ms. Cummings a copy of the certificate of intent to purchase Schuyler Avenue and ask her to execute it?
I can't speak to their reasonableness one way or the other.
The city of Atlanta, if their position was that they needed to get a new abandonment procedure, and if their position was that they needed Ms. Cummings to say whether or not she wanted to buy the half of the property adjacent to her property, would that position have been reasonable or unreasonable?
I can't speak to that. I don't know what I won't pretend to know what the city thinks, and frankly don't want to pretend I'm the city's right.
Do you believe it's clear that the city of Atlanta should have performed under its contract to deliver the quitclaim deed for Schuyler Avenue to Mr. Jones prior to this litigation?
I haven't formed an opinion on that one, where I haven't studied that, and I've not interviewed the city to find out what their rationale was. But, you know, from the pleadings in the case, it appeared clear that they recognized that they had dropped the ball, because as soon as they got in, Patrice got a deed, closed the circle, end of issue.
If that's the case, and if the city needed to have this brought to its attention so that they could close the issue, why was it ever necessary to sue Ms. Cummings in the first place?
Because she was asserting title to property that was owned by Mr. Jones.
What document are you relying on for the position that she was asserting title to that property prior to this litigation?
Well, her counterclaim seems to suggest that.
Prior to this litigation is my question.
I wasn't privy to all that. I mean, I'm here on fees. I'm not here on, the minutia of what happened pre-suit.
You said that it's tricky to sue a municipality directly and that the case might be subject to dismissal if not brought as a quiet title action. Did you have an opportunity to develop an opinion concerning whether Mr. Jones could have sued the city of Atlanta directly on his contract to purchase the Schuyler Avenue property?
Could he have done that? Yes. Was it reasonable for him not to do that? I don't know, because I don't know what the exchange back and forth was. This was a declaratory judgment action where I think he was seeking to obtain marketable title, and your client was counterclaiming, trying to do the same. It was limited as between the parties. You know, was it necessary that they? Well, your question though was whether he could sue the city in a specific performance action, and I suppose that was an alternative approach if they deem that to be necessary or appropriate.
Did you read Mr. Jones's ante-litem letter to the city of Atlanta that was prepared by Mr. Robinson?
I have not.
Okay. Are you aware that Mr. Jones and Mr. Robinson were threatening to sue the city of Atlanta prior to litigating against my client?
I'm not aware of that.
Are you aware that Mr. Jones's lender, Mr. Kellum, was applying pressure, financial and time pressure, to get title to this property, however Mr. Jones could?
Let me interrupt before we get an answer and say this. I think that we are straying back into re-arguing the point whether or not Mr. Jones was justified in filing the action that he did against Ms. Cummings. And I have already said that I believe that decision was problematic and that might merit some amount of attorney's fees. So let's move on.
Certainly, Judge. And the reason I'm asking these questions, by the way, is just so Your Honor understands, I got about 2 more questions here, but the reason I'm asking these questions is because I'm interested whether the expert witness has had an opportunity to consider the facts from the other perspective, which might have justified the amount of time that was spent on them. So that's the relevance in my mind to these.
Understood.
Thank you. Mr. Schneider, I thought I heard you testify, and forgive me if I'm not being specific enough about the question, but I thought I heard you testify that the less and accept provision was a meets and bounds provision in the deed that explained what was being conveyed and what was not being conveyed. Is that a fair characterization of your testimony, or did I misunderstand that?
No, it's not accurate. I don't believe I said meets and bounds. It was a less and accept, I think, reference to the alleyway. And I can't recall off the top of my head whether that was meets or bounds by reference to a survey or plat or some other method of delineation of the area in question.
Did you have an opportunity to develop opinion as to whether or not the 1994 abandonment ordinance was actually still, ask this question the right way, was valid as of the date of the initiation of this lawsuit?
No, or the amount of time I would have spent on this, I'm not billing anything for this, would have been significantly greater. As you're aware, the city of Atlanta issued an omnibus abandonment of all alleys throughout the city, except for 2, and this isn't one of them, at one time. And I know there's been that's created a tremendous amount of confusion throughout the city of Atlanta, which frankly, that's why when I saw this case, I was like, this is a problem that the city has created. It has these poorly drafted ordinances, and but the city has never backed off saying it's not valid that I'm aware of.
That you're aware of. Thank you. I think that does it for me. Thank you. I don't have any further questions for this witness, Judge.
Ms. Bryant?
I don't have any more questions for Mr. Schneider. If I may, Your Honor.
Yes.
I wanted to ask you about the timing that we have and give you an idea of what I would like to do with the time that I would be allowed so that I can make sure that I do the things I'd like to do in the time that I have.
Okay. I have a surrogacy hearing at noon. And it'll take about 5 minutes, and then I had hoped to get lunch. And then I have to bench a law student who is preparing for a very important argument for a grade at Mercer, for an oral argument. And that I think is at 1:30. So those are my hard deadlines.
I don't mean to take that much time. I just wanted to make sure. I would like to have an opportunity to ask Mr. Howard a few questions.
Yes.
I would like to have Mr. Tusink give a little bit more expert testimony just on the reasonableness of fees. I don't envision going so much into the types of questions that were being asked about the litigation. And I would also like to give Mr. Blazer a short amount of time to address the court if that's possible. He's here.
I'm happy to accomplish all those. I think they're doable in the amount of time that I can afford. But right now, if I may, before we transition, I'm going to go get one more cup of coffee. It's 10:46. If we could all just maybe 4 or 5 minutes and get back in here as close as possible to 10:50, and then we will resume with your presentation, Ms. Bryan. Okay?
Thank you.
Just very quickly, am I excused from this, or am I?
As far as I'm concerned, you are, sir. You're welcome to go, as long as Ms. Bryant says that she doesn't need anything more from you. It was nice to meet you, sir, and I'm sure I'll run into you again sometime.
Right. Thank you.
Thank you. You may call your next witness.
Okay. My next witness's chair is empty.
No worries.
Well, if you'd like, I can pivot to my questions from Mr. Howard and then go back to Mr. Tusink when he returns.
I think that's reasonable.
Okay, great. Can I ask the court reporter to swear Mr. Howard in?
I'll do it. Mr. Howard, will you raise your right hand, please? Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir. You may go ahead, Ms. Bryant.
Yes. Hello, Mr. Howard. Although we have addressed each other over the life of this litigation since I've been involved, I'm not sure we've actually met, so it's nice to meet you. Can you formally state your name for the record?
My name is Fletcher Beaumont Howard.
Okay. How many cases have you filed or defended that are quiet titles or declaratory judgment actions?
I would have to guess about declaratory judgment. I think the answer is probably somewhere in the range of 15 or 20. Quiet title, the answer would be probably 1 or 2.
So 15 or 20 for declaratory judgments, 1 or 2 for quiet titles?
Yes.
Okay. In those cases, do you typically represent one side or the other, plaintiff or respondent?
Well, declaratory judgment, as you know, I don't want to give you the wrong impression. I wouldn't say that every single time I've filed or defended declaratory judgment action, it's in a real property case, but many of them have been.
Okay, how many of the cases have been real property cases having to do with title to land?
Honestly, I would have to guess, but my experience in cases that involve, at least as a collateral issue, title to land probably dates back to 2005 or 6 when I started working at Chamberlain Herdlicka under Jimmy Ball and David Autry. And I spent a lot of time in my young legal career doing real estate-based business litigation, and these kinds of issues came up regularly. Who owns the property, all of that kind of stuff. So you're asking me to think back a long time. My current practice focus is what I bill myself as is labor and employment attorney. But I still have real estate developer clients, and I have occasion to litigate both on the offensive and defensive issues that have to do with at least collaterally title. But I would be misrepresenting myself if I said that was a main focus of my practice, at least for the last decade.
Okay, well, my question is going to be in the last 5 years, how many cases have you litigated having to do with title to land?
I suppose we're going to count this one. I have a series of cases on behalf of a series of clients for named Liberty Capital, Hampton Island LLC, Fulcrum Loan Holdings LLC. Those all relate generally to title to land. I've had some title cases that have to do with a real estate development on the coast, Hampton Island Preserve. I'm trying to think other title cases that I have had. Those are the main ones I can think of. So maybe 5.
Okay, so 5 title cases in the last 5 years.
I am not a title case expert. If you want me to admit that, I just admit it.
All right. Does your firm employ paralegals?
Yes, our firm does employ paralegals, but not that many.
Okay. So in your firm, tasks like preparing an appendix, is that typically handled by an attorney or a paralegal?
In a case like this, if I could find a paralegal, we don't have one in our Atlanta office. What I would normally do is I would normally go get a young associate, to help me with something like that. We don't actually have dedicated administrative assistants either. So, we would have to farm something out to something that we call the ARC. It's all theoretically very efficient, but as you know, sometimes it's easier just to deal with something in person.
Sure.
But if your question is about, why did I prepare an appendix of exhibits that, we attached to our motion for attorney's fees, the answer is because at the same time that I was preparing the appendix, I was reviewing the documents and, familiarizing myself with the facts.
Okay. I'm going to come back to that. I believe it was one of your associates who billed specifically for preparing an appendix, but how about preparing a certificate of service? Is it typical for a lawyer in your firm to bill for that?
Ms. Bryant, forgive me for interrupting, but I think I've already said that
Okay, that's fine.
I don't intend to the extent I'm going to award fees, I intend to make reductions for things that were administrative in nature that should most properly have been done by an administrative assistant or a paralegal. And so I don't think I'm able to review the bills and observe those entries as well. And so I don't think that you've made your point.
I'm comfortable with that, by the way. If we had had this discussion before this hearing, I think we could have agreed on this point.
So I counted 64.9 hours on the motion for attorney's fees. Is that typical of how long a motion would take in your mind? Or does that seem high or low?
64.9 hours on the motion for attorney's fees sounds to me like it probably includes my time preparing for oral.
It does. It's 48.4 drafting, and I think the rest is preparing for oral argument.
It seems typical to me when you're preparing a significant motion especially when it's factually involved and intricate, for it to take about a week. There's research that goes into it. There's outlining, there's getting together with your co-counsel to make sure everybody agrees that what we're doing is reasonable. There's drafting, there's a couple of revisions, there's putting together the exhibits and all of that. Does that take about a week's worth of billable time? Yeah, in my experience, it does.
Okay. I'm going to ask you a similar question about the overall billings in this case. I counted 245.9 hours. Does that seem typical or high or low?
I think that this case potentially could have been very different if the position had not been taken at the outset that Mr. Jones had legal title to the property, and then if he hadn't kind of retreated behind his counsel and been cagey about those facts. So I think that the hours on this case were appropriate based upon the investigation that had to happen to disprove the position that was taken and repeatedly taken throughout the litigation.
So why did it take so much time if your client was also claiming she owned the property? Help me understand how the plaintiff's claims of ownership expanded the litigation at the point that your client also claims that they own that same property.
I disagree that my client did anything that expanded the litigation. And I disagree that my client was claiming anything with respect to Schuyler Avenue prior to the filing of the litigation. Ms. Cummings' position was—
That wasn't my question. I wasn't asking about prior.
Okay.
I'm saying during the life of the litigation. How did the claim of title versus a claim of some title interest expand the scope of the litigation where your client was also making claims to own that same area?
You're asking how specifically the false claim that your client, I don't know if it's your client, the false claim that Mr. Jones held legal title to the property, how did that expand the litigation? Is that the question?
I want to know your argument for, yes, that's my question for you. I disagree with the characterization of a false claim, but I want to know how the claim of Mr. Jones's claim of title expanded the scope of the litigation when your client claimed that they owned that same property.
I'll answer you in two ways. I'll first off, it's not like the only claim in this litigation was a declaratory judgment claim or an eventual quiet title claim. This claim was initiated, or the case was initiated with both a declaratory judgment claim, which stated and asked for a declaration that your client held legal title to this property. And it was also, there was an ejectment claim, claiming that Ms. Cummings and her fence around her backyard was trespassing on Mr. Jones's land, that he held legal and equitable title to that property, that because she was a trespasser and because he had asserted a tort claim, he was claiming that she should be made to pay his legal fees under whatever the statute is, 13-611, which was a separate count that he asserted. So the claim that he already held title was a necessary element to his ejectment claim. And his ejectment claim was a necessary element to his legal fees claim. So that's how it expanded the litigation. All of that has to be viewed against a backdrop of all of the written correspondence that had come from Mr. Jones and Mr. Robinson prior to initiating the litigation, where they repeatedly told Ms. Cummings that Mr. Jones already owned the Schuyler Avenue property, that he was going to be suing her, that she was going to end up paying his attorney's fees. So she had been threatened with litigation by them, before this. Then they did it. And it seemed for whatever reason that they were taking a very aggressive posture with respect to this fees question and this ejectment claim. It was also,
So I'm not sure that
it was also, I
answering my
apologize,
question.
I'm not
Hang on,
done.
hang on. Listen, stop. I'm going to say this one more time, y'all. When I ruled that Ms. Cummings was entitled to potentially receive actual dollars for 9/15/14B damages, I already made the determination that Mr. Jones could have properly brought a suit related to his claim under the less than accept, but that the manner in which it was brought satisfied the requirements of 9/15/14B. And I don't know that arguing over whether or not I denied the motion that Mr. Jones filed about the argument that I denied the motion. Yes, I denied the motion that Mr. Jones filed, arguing about the expansion of the scope of the litigation by Ms. Cummings. And so to the extent that what you're trying to get to goes directly to the amount of billing that is being sought, I need you to tie that knot tighter, because it sounds like what Mr. Howard is doing in response to your questions is re-arguing the underlying substance. And I don't want to hear that. And I don't think I need to hear that again.
And I apologize, Your Honor. I'm trying to get an articulation of what it was that was actually sanctionable. And I'm not trying to relitigate the motion for attorney's fees. So I will try to target my questions more narrowly for that purpose.
Well, in fairness, Ms. Bryan, it's not just your questions. It's also Mr. Howard's answers that I think are going way further into the weeds than I need for you to be. But in any event, go ahead.
Well, I apologize. I'm just trying. I apologize.
Okay. During our last hearing, Mr. Howard, you stated that Ms. Cummings, I don't have the transcript in front of me and I don't mean to put words into your mouth, but you said something along the lines that she is very much paying her attorney fees in this matter, when there had been some question about whether you were doing this pro bono and that type of thing. I noticed that the invoices only reflect one $5,000 payment by Ms. Cummings. Is that all she's paid you in attorney's fees?
I disagree that I said that she's paying them, but she has paid 5,000. I believe what I said was that she's obligated to pay them.
Okay, has Ms. Cummings paid anything more than $5,000?
Not yet.
Okay. Have you made arrangements with Ms. Cummings to be paid on a contingency?
No.
Okay. I'm sorry, just give me a second to go through my questions. That's all the questions I have for Mr. Howard. If Ms. Jett has any questions, I don't know if she does or not. I have not spoken to her about it, but I didn't want to be all done before someone else maybe had questions.
Ms. Jett, any questions for Mr. Howard?
Your Honor, I did have 2 pages of questions, but I think Ms. Bryant got them all in front of me, so I don't think I have anything additional.
Okay, thank you.
Am I excused, Judge?
You are excused from the witness stand, the metaphorical witness stand. Ms. Bryant, you can call your next witness.
Okay. I would like to call Eric Twisink to the stand, please. Can I please ask that you swear him in?
Sure, Mr. Twisink. Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You may lower your hand. Go ahead.
Good morning, Eric. Can you please state your name for the record?
Yeah, Eric Tusink.
Okay. Are you a licensed attorney in Georgia?
I am.
Let
What
me,
is your
forgive me for interrupting, and to the extent you need to make a record, I understand, but Mr. Tusink has, as have you, Ms. Bryant, worked as a special master on behalf of the Superior Court of Fulton County and me personally. I'm also, Mr. Tusink filed an affidavit regarding his CV, so I feel like his qualifications are in the record, and I certainly am aware of his qualifications. Go ahead.
Okay, I'll try to be brief. What is your area of practice?
I practice title litigation, and also I do a significant amount of commercial lending work for both lenders, borrowers, etc.
Okay. What is your current role with Williams Tusink?
I'm the managing partner.
Okay. In your role as managing partner, do you review bills that your firm issues to clients?
Every single month.
Okay. Are you familiar with prevailing market rates for legal services for cases of this nature in this marketplace?
I am.
Okay. Have you reviewed the billing entries submitted by Mr. Howard in this case?
I have.
Okay. Have you also reviewed the pleadings in this case?
I've reviewed a limited subset of the pleadings, only so much as to allow me to get a framework of the basis of the facts and circumstances of the case.
Okay. What is your opinion of the time spent on tasks in this matter?
I felt like they were excessive given the nature of the controversy.
Okay. Are there any time entries that jumped out to you in particular?
I mean, I'm loath to say it, obviously the administrative tasks, but yeah, I mean, it's not so much, I mean, there are specific entries that jump out at me, and just, I don't have them in front of me, and obviously, you know, memorization, but I mean, one that sticks out to me specifically is there's an hour spent researching like whether a special master will make the determination on the facts and whether you'll still be entitled to a jury trial. I noticed that as being something like that myself, Ms. Jett, you, the other members kind of the title bar just know all, you know, like it's written on the back of our hand, so to speak. But more my observations were just on everything, on every kind of phase of the litigation, it was just more than we would see in our firm, or what I would understand to be common in title litigation matters kind of in the metropolitan Atlanta area.
Okay. I'm going to ask you about some specific entries, but I don't expect you to necessarily have them in front of you, okay?
Yeah.
So an answer in a declaratory judgment quiet title case, how long would that typically take?
With the caveat, obviously, that all matters are different, but I mean, I usually would account for something like 3 to 5 hours for an answer in a matter like this.
Okay. How about like a motion to dismiss? How long would you typically see for a motion to dismiss?
You know, we don't frequently file. I mean, I file a motion to dismiss in other cases, but because these cases are ultimately always decided kind of on motion for summary judgment because of the nature of the work, I would say a motion to dismiss maybe 4 to 6 hours, 4 to 8 hours, something in that range.
Okay. How long does it usually take you to review a title?
What's the title look like?
Residential, not commercial. Something like the property in question here.
I mean, and that, Mike, I'm sorry, I wasn't trying to be too cute by half there. You know, titles can be messy and they can be clean. A title, something like this, you know, 30 minutes. I mean, not long. I mean, but it really depends because, you know, I'm working on a matter now where there's 50 or not 50, excuse me. There's 15 to 20 material liens or construction liens on that. And obviously having to dig into each one of those and then analyze the sufficiency of that lien takes a lot more time. So it really depends. But in this case, the title was pretty clean. So, I mean, I could dial down on it pretty quickly.
Okay. How long would it typically take, you think, for drafting a motion for attorney's fees?
I'm trying to think of the last one I did, but 8 to 12 hours. I mean, it could be anywhere. It could be as little as 5, as many as 15, but you know, but yeah, I mean,
That's
these are
the
extreme.
range.
Those are kind of extreme cases, but yeah, somewhere 7 or 8 hours would probably be the sweet spot. So,
when clients bring cases to you, do you ever provide budgets or estimates of what it might cost to litigate the case?
I do.
Okay. For this case, and obviously we all know as lawyers that you don't know what's going to happen over the life of a case, but for this type of case, what budget might you have given somebody like Ms. Cummings if she had brought this case to you?
You know, with the caveat that you're just talking about my fees, right? Because obviously you run into the issue, as we all know here, where you end up paying the special master's fees, and those can be variable depending on who you get. But for something like this, I would probably to take it all the way through motions practice, you know, assuming that it's not going to go to a jury trial, that it's going to either be decided by a special master on a motion for summary judgment, or it's a deck action where it's being equitably decided by the court. I would probably ballpark it at, and that's everything, including just probably $25,000 to $35,000 total for every single thing. So.
Okay. Those are all the questions I have for Mr. Tusing.
Let me just ask one clarifying point, Mr. Tusing. Did you, when
Yes.
you just said you would ballpark 25,000 for the entire thing, you meant the entire thing, not just the motion for attorney's fees, right?
Correct. Yeah, I meant
Okay.
that's complaint, limited motion practice. This case had some interesting motion practice in it, oppositions to scheduling orders, things I don't typically see, usually that are done by consent. Discovery, assuming maybe a couple depositions in there, because sometimes you do need fact witnesses. And then motions for summary judgment, or preparation for a special master here. I mean, it just depends. So, but yeah.
And to be clear, I wasn't questioning your opinion as much as I was making sure I understood what it applied to, and that you were talking about all in terms of the litigation on behalf of Ms. Cummings.
Yes, correct, Your
Okay.
Honor.
Thank you. I appreciate that. And I think you had tendered your witness, correct, Ms. Bryant?
I am done for now.
Okay. Mr. Howard, questions for this witness?
I think you're muted, Mr. Howard.
Yeah, you're muted, Mr. Howard. It would not be a Zoom hearing if we didn't have to say that at least once.
There we go. It's too late in the pandemic for that kind of behavior. I apologize. Mr. Tusik, I actually recognize you. We live in the same neighborhood, correct?
Yeah, we are neighbors, and before this, you know, I can be reticent to take yeah, I typically don't take any quiet title matters personally in kind of Grant Park specifically, and even in a little bit wider Southeast Atlanta neighborhood. Just it's not worth it to me. Kind of good neighborliness is more important than billing some fees. But yeah, I think I asked my wife, and I think she had met your wife before, but I don't know that we've encountered one another in and around the neighborhood.
I don't think so either, and we won't take it
Just when
personally.
people think that Atlanta is a big city, we've got people with all kinds of interesting connections.
Well, I mean, I think in Grant Park, Your Honor, if every third house has at least one lawyer, if not two.
Yeah, no, Mr. Tusink's child runs on cross country at Maynard Jackson, where my kid plays baseball, and we've been in similar places, I think, just passing one another. So
Yeah.
Jim Paisley said you're great. So there you go.
He and I were hanging out last night at the Lawyers Club party, but I want to thank the judge here briefly. Sometimes after the Lawyers Club, I don't feel my best, but because I had to testify here this morning, I got a great night of sleep. I was drinking soda water throughout the night. Like, you brought out my best behavior, and I'm very much appreciative of that.
Glad to help out, Mr. Tusink.
Okay, well, I'm going to try and be brief here, but Mr. Tusink, you described this. You said all matters are different, but then you are answering a question about how long it should take to file an answer in a quiet title action.
That's correct.
Do you recall that testimony?
I do, yes.
Okay. Would you describe this as a quiet title action?
Yes. I mean, I suppose, colloquially, that specifically, it's an action to clear title or to clarify title or to obtain marketable title. But, quiet title is one of the pathways to which you can achieve that result.
When you were I appreciate that. You're aware, of course, that there was no quiet title claim filed in the initial petition, correct?
Yes. They went the declaratory judgment route, which can on occasion be a preferred route or a cleaner and quicker route. It's often a judgment call by the litigator.
Are you familiar with the other counts to the initial petition?
I know there was an attorney's fees one in there, and then, I did review it, and I think there were 3 counts. There was declaratory judgment, and then, there's an ejectment, wasn't there? Which is also typically you would put that in there as well. Because obviously if you're saying this is your property or you have title to it, right? Then you're also going to ask if the other party has any fence or items or whatever the case might be. I think there's something like that here. You would also want to bring an ejectment action for that to be removed as part of the matter.
How many? I want to see if I can zero in on the crux of what I want to ask you without going as granularly as I did before. But how many hours did you spend reviewing pleadings in this case?
Probably 6 to 8. And
I think you said that you reviewed some, but not all of them. Is that right?
Yeah, no, I just don't think, legal economy is important, I think. And I don't know that spending probably the 20 hours that it would take to go through everything in depth would provide more value, significantly more value. I think there'd be declining marginal returns beyond kind of what I did.
Thank you. Did you review any of the written discovery in this case?
I did not.
So, and I presume none of the responses to the written discovery?
Correct.
Okay. And that would have taken some additional time for you to review, and legal economy being what it is that a fair way to characterize it?
That's right. Yeah. And why not just disclose? Yeah. I do intend to bill Mr. Robinson a flat fee of $1,500 on this. And so, in order to but maybe I would have done more if I'd known how long this hearing was going to go, but here we are. So.
Okay. Thank you. And similar questions that I asked the other witness. Has anyone made you privy to, my efforts to obtain information about ownership of the Schuyler Avenue property from the city of Atlanta and how difficult that might have been?
Could you clarify that? Make me privy. I'm just a little bit confused as to exactly what you're asking.
Good clarifying question. I guess, do you happen to know what efforts were required of me to try and get an answer from the city of Atlanta as to whether or not they currently owned the Schuyler Avenue property at various times in this litigation?
So I was able to discern some of the efforts that you had undertaken, both from your billing records and also from some representations contained within, I believe, the motions and or the responses there too.
If the city of Atlanta was not giving me a straight answer to that question, would that affect your view of whether or not my time spent was reasonable? At least on that issue.
What question?
The question of whether or not the city actually owns Schuyler Avenue at various points in this litigation.
I mean, I think within kind of the title litigation bar, the inability to get a straight answer or be able to obtain information from the city of Atlanta and or other government entities is a pretty widely known problem. I'm not sure that I answered your question there. I apologize if you want to restate it.
I guess my question is, do you think I specifically overbilled my time trying to obtain an answer from the city of Atlanta as to whether or not they owned the property during this litigation?
Well, let me, Claire, one thing is that I know, you may have wanted to invoke the rule or something. I'm in no way and don't intend to testify that any of your entries were not genuine. I believe that all time you entered there was accurate and reflected the time you actually spent on this matter. I would say that, and I'm using this phrase in its meaning, is that some of it appeared to be a bit of a fool's errand, and I'm not calling you a fool. I'm just using that like common in that.
I'll take it as it's intended.
Yeah, that it still seemed excessive to me. I think you were in search of an answer that somebody experienced in dealing with the city of Atlanta in these type of matters. Excuse me, I need to work on my elocution exercises. Would have been aware that it probably would not be forthcoming, and also that the city's position on that, that it would be difficult and perhaps not valuable to obtain the city's position on that.
When you were testifying previously about a $30-something thousand all-in budget to someone like Ms. Cummings, was that based upon your experience, I presume, handling other quiet title actions? Is that fair to say?
Yeah, and again, that quiet title actions or other matters involving clearance of title or obtaining marketable title on behalf of clients or defending. I mean, well,
how often do you have a quiet title matter where there is a claim for attorney's fees?
It's fairly rare. I can only think of one in the recent past where we have sought them or defended them. And it's usually in instances of particularly egregious behavior. It's not common. And it's also my practice to never, I like to say there's a special place for attorneys that represent to their clients, that try to engage clients. And I'm not saying that's what happened here for you, by the way, as a way of a clarification, for attorneys that, get clients to pay them retainers while representing to them that there is a likelihood or even, a reasonable possibility of having their attorney's fees paid by the other side, because I just don't see that as being particularly common. And so, I don't see attorney's fees frequently paid in these matters.
Did you have an opportunity to review any of the pre-litigation correspondence from Mr. Robinson or Mr. Jones to Ms. Cummings?
I did see a little bit of that, yeah. If you're asking me to recall it in detail right now, I mean, I can't, but I do recall that there were, Mr. Robinson did, I think, something I would do. I can't look into the mind of Mr. Robinson necessarily, but it appeared he was offering, I think he was of the correct position that Mr. Jones had, all the rights to this particular paper street, Schuyler Avenue. But we probably take a similar position to what I do, is that you could either pay me some money and maybe, or deal with the uncertainty of litigation and ultimately get this, or you could pay Ms. Cummings some money and get definitiveness. And as much as, I'd like to, as you probably are too, put some money into my kid's college account, I'd rather see the client get a good result and pay the same amount.
Sure. Are you aware of whether or not Mr. Jones, through Mr. Robinson, was threatening legal fees even before this action was filed?
I don't recall that. It doesn't mean it's not the case. So,
Okay. Would you agree with me that the threat of legal fees, particularly where your client believes the other side is serious about trying to obtain them, changes the stakes of the litigation somewhat?
not really in that it seems in the practice these days that threats of attorney's fees in initial demand letters and initial letters is almost to the point of being surplusage, right? Everybody puts it in there. And when your client gets, I mean, typically my client gets a letter that says that, I was like, yeah, everybody says that. That seems pretty unlikely. Don't be scared by that. It's just things lawyers do.
If they had succeeded in ejecting her from the property with their tort claim, I guess perhaps they would have proceeded as they did at the end of this case and sought fees for the ejectment. Do we? I mean, that's, well, never mind. It's okay. I'll withdraw the question.
Okay.
I think it's about to be argumentative anyway. You said you raised an eyebrow at my spending an hour to research the question of whether or not a special master would make all the factual determinations, or whether I could get a jury to answer those questions. Do you know the answer to that question? Can I get a jury to look at the factual questions that the special master reviews?
In limited circumstances, yes.
Would I be correct in assuming that the bar of title attorneys that serve as special masters is pretty tight-knit bar in the city of Atlanta?
Well, let's see. Yeah, I mean, Mr. Robinson, I consider to be a mentor here in Decatur. Miss Jett and I are litigating against one another right now. Miss Bryant and I are litigating against one another right now. So yeah, it's a pretty small bar.
So then it's not exactly an unprecedented circumstance that two of the three special masters that were specifically requested in this case have turned up as counsel in the case, in Miss Jett and Mr. Ayub. Is that fair to say?
Yeah, I mean, we're lucky here in Fulton County to even have 3, 4, 5, 6 options, I think, to serve as special master. There are 159 counties in Georgia, and the way the statute is written is that many counties, it's virtually it's almost impossible to find a special master. So yeah, no, I mean, no, I mean, there's just not a huge universe of people who have the kind of specialized knowledge necessary to do that work on behalf of the court, and we're always honored to be able to do so.
Thank you for that. I think you testified that you found it odd that I filed a motion opposing an amendment to a scheduling order. Those things are typically done by consent. Do you happen to know whether the amendment to the scheduling order was something that had been requested of us before the motion was filed?
I do not.
Do you happen to know what amendment to the scheduling order was requested?
I'd have to go back and look at it. I don't have the recollection after looking at it.
If I told you that the amendment that was requested was requesting the parties to be ordered to mediation prior to, or at a date that would be prior to the completion of discovery on relevant factual questions in the case, would that be a reasonable basis to oppose it?
It's difficult for me to, I mean, reasonable, I suppose. I'm a licensed mediator, and I'm a big fan of mediation, and I honestly would support legislation in this state to require mediation before discovery, and I'm very appreciative of judges who order early mediation. I think that solving matters through litigation is a terrible way to do things, but the only other worse, or I mean, it's better than pistols at dawn, so to speak. So yeah.
But sometimes not much, right, Mr. Toussaint?
Not much sometimes, Your Honor. I think I might get better sleep sometimes the morning before a duel than I would be before facing some opposing counsel. Nobody in this room. I want to make a point. It's going to be totally off topic, but we're talking about dueling. This is your I'm sorry to waste the court's time. The fact that we're talking about Schuyler, and this is going to be a big nerd point. We're talking about Schuyler Avenue, and there was a lawyer named Alexander Hamilton in this case.
Trust me.
Like blew my, I was like, oh, like I thought we're in the Matrix for a
Yeah,
second.
my whole family, we went to see Hamilton on Broadway, and I had the same thoughts every time this case came up. All of my kids can quote the entire thing verbatim. I almost can. So yeah.
Anyway, sorry. I had to. Sorry. All right, Mr. Howard, I'm sorry. I just that it's hilarious to me. Sorry.
I'm sorry. If you want one more touch point to the theatrical production, Mr. Hamilton is an African-American attorney as well. So there you go.
Oh, all right. Well, it's
so he was a very kind person, and I enjoyed dealing with Mr. Hamilton. But I thought it was fun as well. You quoted $30-something thousand all in as an opinion of what it would cost for someone in Ms. Cummings' position. I took it that was not inclusive of the fees motion, or am I wrong about that?
No, yeah, I think that would not be inclusive of fees motion scenario. Yeah, that's fair to say.
Did you have any opportunity to develop an opinion about whether the 1994 abandonment ordinance was still valid at times, relevant to this litigation?
I didn't have time to, it wasn't really kind of within the scope of what I'm doing. I don't have any reason to believe it is not valid. It was interesting to review, in that typically, like as Mr. Snyder said, and he may have, I don't know if he confused the point or not, but, the 1970s abandonment of alleys law is the gift that keeps on giving to title litigators. And this was unique in that it was a specific abandonment of a street as opposed to an alley.
Right. So you don't have any reason to believe it wasn't effective, but do you have any reason to believe it specifically was effective?
I guess I would say that all other things being equal, I would, a statute on the books that I couldn't find, that there was no record of it being repealed, I would assume is effective. But I don't know that that record may exist. So,
were you aware of whether the city of Atlanta had ever taken a position that it was not effective?
was I aware of that prior to reviewing
And when you,
the record of this
during the
case?
review in this case, did you become aware that the city of Atlanta at some point took the position that the abandonment was no longer effective?
I'm aware that, and this is probably pointlessly splitting hairs, but I was aware that the law department took that position at one point, or it appeared that the law department took that position.
On behalf of the city, correct?
Yeah, they're the city's lawyer, so yeah, that's right. They're their agent, so that would apply.
And are you aware that that's why the city of Atlanta would not sell the property to Mr. Jones without getting a consent form signed by Ms. Cummings?
Can you ask that question again, please?
Are you aware that the city law department's legal position that the 94 abandonment ordinance was no longer valid was the reason that the city of Atlanta would not sell Schuyler Avenue property to Mr. Jones without getting a consent form signed by Ms. Cummings?
I'm not sure. I'd have to go back and review the pleadings and record again. I understood that the city, in my opinion, based on what I've seen, needlessly, wrongfully, were trying to request this consent form, but I don't, the nuance of it, I don't recall.
Is it your opinion that the city of Atlanta should have conveyed the property to Mr. Jones before this litigation as a result of the contract that they had?
Upon tender of the value pursuant to the statute, yes.
So then, would you agree that Mr. Jones had a viable cause of action against the city of Atlanta for failure to tender the property, or failure to deliver the property or title the property?
With the caveat that I know that, and I would have to get into this review a little more closely, with the caveat that, issues of sovereign immunity were at play here, I would think that potentially, yes, they would have an action against the city of Atlanta for breach of contract. And obviously, for breach of contract matters, the standard is not quite as stringent as in tort and other matters in regards to sovereign immunity, although sovereign immunity with recent legislation and case law has become a bit of a moving target that everyone needs. Seems like it's a bit of a magnet for malpractice.
Did I hear you testify? Did I hear correctly your testimony that you did not think the city of Atlanta had a basis to ask Ms. Cummings to sign the certificate of intent form, releasing her, allowing them to sell the property to Mr. Jones?
A proper legal basis? No.
Do you have any reason to believe that Ms. Cummings, were you aware that the city of Atlanta was telling Ms. Cummings that she could purchase the half of the property adjacent to her property if she would just check the form yes?
I believe I saw that somewhere in the pleadings. Yes. So yes, I'm aware of that.
But you don't know one way or another whether that actually happened or what was said, right? I mean, you weren't privy to those conversations.
Wasn't privy to the conversations. I saw it either represented in a factual discussion. I think that it was discussed in one of the various and sundry motions that I reviewed.
Do you have any reason to believe Ms. Cummings needed to go get a lawyer to opine about whether or not she really had to sign this form? Maybe that's a bad question. If the city is telling Ms. Cummings that she can check yes or no, what compels her to check one way or the other?
I feel like you're asking me to look in. It's a tough question. Are you asking me to look into the mind of Ms. Cummings, or could you rephrase that in a way?
Not really. What I'm really asking you is, if the city has given her a copy of the certificate of intent, and what it says is, would you like to purchase this property, yes or no? And do you agree that your neighbor can purchase this property, yes or no? Does Ms. Cummings have any legal obligation to check the box stating that she would like Mr. Jones to be able to purchase the property if that's not how she really feels?
No, she has no legal, based upon, I'm still trying to think about your question, and I'm not trying to be too smart to hear, but
I don't think I need the answer to the question. I think Mr. Howard made the point by asking the question. And
okay.
we can move
Yeah,
on.
I'm not following what you're asking me here.
It's okay.
I think that it confused the situation. I think the city of Atlanta was a bad actor in this instance and greatly confused the situation for everybody, and that the parties sitting in here were probably all harmed by the actions of the city.
I completely agree, Mr. Tusink, but unfortunately, the city of Atlanta is outside of my purview today.
Boy, I wish I knew everybody felt that way. Let me just think if I have any other questions for Mr. Tusink, but I think probably I may not. Mr. Tusink, did you go line by line through my bill and X out things and create a specific number based on the tasks that I did? That
I did not.
Were specifically unreasonable?
I did not. I think my analysis, there are some things that I think were unreasonable, but they've been discussed here, and Judge Krause could probably do a better job than I could in reviewing that, which she intends to do, as she said several times here. My analysis is more just based on what's market, in that you and I live in the same neighborhood. We have ostensibly the same job, but in many ways, you work at a very large law firm, and I work at I manage a 13 attorney law firm in downtown Decatur. And so in many ways, although to a layperson, it would seem like we are simulacrums of one another, we have very different jobs and almost occupy different worlds. And so my analysis is just based upon living in kind of the legal bar that I'm in the community that I'm in the work that I do, what I think is normal and what I think are reasonable fees for that. And so, as I said before, I 1000% believe that every hour that's in there was actually billed. And, I don't maybe necessarily disagree that some of what you billed was necessary for you to litigate the case you wanted to this way. But what I'm saying is that is well outside the norm of what I see, and that the amounts were frankly somewhat eye-popping to somebody who does this all the time.
No, thank you. I appreciate the testimony. Would you agree with me that there are cases sometimes, though, that are outside the norm that require additional work?
Absolutely.
Do you have any basis to say with certainty that this isn't one of them?
I mean, there's no case that is the norm. I will say that this had some interesting issues in it, as they all do. But I would not testify. I'm not testifying here today that this was the type of case where fees are driven to the amounts I see reflected on your bill.
I appreciate the testimony. I don't have any further questions for this witness, Judge.
Thank you. Thank you. Ms. Bryant, do you have anything else for this witness, or Ms. Jett?
Your Honor, I intended to ask Mr. Tusink about the commonplace aspects of including an encroachment claim, an ejectment claim when there are encroachments on the property, but I think he's already sufficiently testified for that, so I won't retread ground already.
Thank you. Ms. Bryant, any redirect?
No, Your Honor.
Okay, Mr. Tusink, you are excused.
Thank you so much, Your Honor. I'm going to go work on a special master order that is badly overdue, and Mr. Freehoff should be emailing me every day saying, where the heck is this thing? So,
well, just tell him that you got held up by Judge Krause in this hearing, and he'll understand. So,
yeah. All right. Well, thank you so much, and good luck to you all.
Thank you, Ms. Bryant.
I would like to let Mr. Blazer address the court for a brief minute, if that's possible. And then I would reserve any legal argument to the extent that the court wants to hear any more legal argument, which I suspect the court does not want to hear any more legal argument for the conclusion.
Okay. Mr. Blazer, I'm happy to hear from you as you are essentially a party in the case. I think for procedural reasons, I guess I will ask, does anyone wish for him to be sworn in to make that statement?
I think he's under oath because he's a member of the bar anyway, Judge.
Okay.
Sure.
Thank you. Go ahead, Mr. Blazer.
Well, Your Honor, this, as you know, I'm named personally in this motion. And so that is the reason that I've sat through all the hearings on this. And if we're going to carry out the Hamilton analogy for a little while longer, there's Angelica, there's Eliza, and Peggy, and I'm barely Peggy in this situation. This case was filed in April of 2024, and the answer and the motion to dismiss were filed in May of 2024. Also in May of 2024, John Robinson filed a leave of absence for the year of 2024 that included the dates of July 11 to July 31, when he was, I believe, out of the country, as I recall, on an extended vacation. And thus, when Mr. Howard filed a motion to dismiss, the petitioner's response was filed in June of 2024. And because John was going out of town, he asked me to sit in on that July 11th hearing that this court noticed on Mr. Howard's motion to essentially be his eyes and ears. I did not present the argument at that motion. It was presented by David Havorka, who did work along with John Robinson in this case. And so the very first time that I looked at pleading number 1 or document number 1 in this case was on July 10th of 2024, the day before this hearing, so that I would have some clue what was going on. I have never met or communicated with or emailed with Scott Jones. He couldn't pick me out of a lineup, nor me him. I have never met nor communicated with or corresponded in any way with Mr. Howard or Ms. Cummings. I had no involvement with any of the parties My name is not on any of the pleadings. My bar number is not on any of the pleadings. I was never added by anyone, whether the firm I worked with or the opposing party or this court as a contact, service contact in this case. I've not received any of the pleadings in this case, other than as they have been, forwarded to me by other attorneys or counsel. So under the category of no good deed goes unpunished, if we're going to bring a little wicked in, I sat in on that hearing for John, and that is about it. Later during that hearing, or towards the conclusion, as I recall, this court said, "Hey, seems to me that the city of Atlanta should be brought into this," which I thought was reasonable. And so David Havorka drafted the amended petition to be filed, and I reviewed that to make sure that it did include, as this court directed, bringing in the city of Atlanta. And thereafter, the next time that I had any, time reflected, it wasn't time that I entered, but around the time in like September of 2024, around the time that the city of Atlanta was appeared poised to issue a deed. By that point, I think the whole, intervening party and all that had arisen. And I had some discussions with John and David, or they asked, well, procedurally, how should we handle this if, we have essentially gotten the relief, that we were after. The deed has been or was about to be issued, one or the other. I wasn't involved in those conversations. Just sort of procedurally, what do we do with this? So that is the extent of my involvement. I just don't think that there, if an appellate court was reviewing this, or anybody else would say that there is a basis under 915-14B to include me personally as an attorney that acted in bad faith.
Let me interrupt you for a moment, Mr. Blazer, and ask Mr. Howard what his position on that is that although I obviously am aware that you were named in the motion and that you were partners, although I don't profess to know the exact nature of the relationship, right?
And that's a valid point.
Right. In terms of Robinson and Blazer, or Blazer and Robinson.
Correct. That was a partnership of professional corporations, not two individuals.
Right. That currently what exists is an email in which the court has pronounced what its ruling is on part one of this motion, right? Which is a finding that Mr. Jones and the very nebulous phrase, his counsel, engaged in meaningful bad faith in terms of the nature, expansion of the scope of the proceeding under 915-14B. And so the court has never drilled down beyond the phrase his counsel to get to the nature of who against whom individually or by corporation or whatever as counsel in that order. The primary focus in my ruling was primarily and my recollection of the hearing at the time was primarily focused on the expansion of the proceedings at the outset by Mr. Robinson on behalf of Mr. Jones in choosing to file an ejectment action that would support an attorney's fees claim. And so I am curious, Mr. Howard, obviously Mr. Blazer was involved in some ways in the litigation. What is Ms. Cummings' position regarding Mr. Blazer's individual responsibility as one of his counsel? And that's the phrase I use is Jones's counsel or his counsel in my email ruling, such as it exists, which has not yet been finalized into an order.
Well, first off, I would hate to see Mr. Blazer named individually as having done some sanctionable thing. I'm not particularly interested in that on behalf of my client. And I don't think she's particularly interested in that. The reason we included Mr. Blazer, obviously he made some appearances in supervision of Mr. Havorka. It was concerning that after the facts came out in the case, concerning to us that Mr. Robinson then retired and the firm appeared to have dissolved and Mr. Havorka appears to have stopped practicing law. If you search his name right now on georgiabar.org, he's got no firm and he's currently ineligible to practice for unlicensed or unpaid license fees. So we were concerned that, among other things, Mr. Jones is going to take the money that he received from Mr. Kellum and go squander it on whatever his other debts are, that would not be a viable place of recovery. And so when we asked for fees against Mr. Robinson or counsel, Mr. Robinson and Mr. Havorka, we also asked for fees against the firm. And since the firm is appears to have been dissolved, we named Mr. Blazer because he seems to be the only one of them that's continuing to practice law and might have some continuing duty on behalf of his former firm as he's winding it down.
Talk about being left holding the bag.
So that's again, I take Mr. Blazer's testimony here at its face, and I believe he's probably he sure seems to me like he's telling us honestly, what his involvement is. We just wanted to make sure that we had some ability to collect against the former law firm of Robinson and Blazer.
I understand that, and that I think will be it may ultimately be a matter for another day. I think that Mr. Blazer's primary point, and I think it's a valid one, is that although 91514B 91514 generally allows for the award of fees against either or both a party and their attorney, that there still has to be evidence of demonstrable bad faith conduct to justify it, and it needs to be by that individual. So ultimately what you may find is that to the extent that Robinson and Blazer, whatever that might be, or to the extent that you might attempt to recover for Mr. Robinson's bad faith conduct that the court has already agreed was sanctionable, that might be a matter for a different day in terms of what the corporate structure was. But the evidence that I have heard before today did not necessarily support a finding of bad faith by Mr. Blazer individually. It definitely supported a finding under 91514B of what I had said before of Mr. Robinson, and potentially by extension to whatever corporate umbrella he was operating under. But that would probably be the extent of it.
Judge, I'm satisfied if the court right now just wants to say Mr. Blazer, didn't do it based on his testimony, and we can withdraw the motion as to him. But until now, I've not heard him say what his involvement was. It seems like a small firm. It seems like a small partnership, and it seems to have dissolved in a weird time period, in connection with this matter.
It dissolved when John Robinson retired. Which he was entitled to do at age 75 or whatever he is,
I hear you, and I apologize for the crosstalk, but it sounds to me like Mr. Blazer has given us his testimony, and on behalf of Ms. Cummings, I'll withdraw the motion against him based upon that. But we'd like to maintain, obviously, we'd like to maintain the motion against Mr. Robinson and the former firm. So, I mean, we may end up talking again at some point if you're the only person left practicing law.
Okay. So I will make a note in whatever final order I enter that during the hearing, Ms. Cummings withdrew her motion for attorney's fees against Mr. Blazer personally.
I appreciate that, Your Honor.
Okay. Anything else, Mr. Blazer, that you wanted to add, sir?
No, Your Honor. This is difficult, because I don't in any way want to be, I practiced law with John Robinson for 28 years, and I never found him to act in bad faith. Neither one of us ever had a 91514 entered against us at any point in those 28 years. So it's tough to seem like I'm distancing myself, but the facts are the facts.
And as I have said, I think a couple of times, and I definitely said in my email ruling, I think that the primary bad faith is on Mr. Jones, and that Mr. Robinson had the opportunity to act as a counselor and provide guidance about what would be legally appropriate, and instead got a little lawyery, as people accuse us of doing. And so that's what the basis of my ruling has been. And that's what I'm going to stick with. Thank you, Mr. Blazer, for being present, sharing that with me. I'm very sorry that you have found yourself involved in this.
It is what it is. Thank you.
Ms. Bryant, Ms. Jett, anything else to present?
Your Honor, I don't think we have any additional witnesses. Obviously, I think you noted whenever we got together first on Monday that there were a couple of additional affidavits that were filed by Hank Stu Smith and Doug McKillop. And I believe you indicated you had already reviewed those prior to our hearing. So I think from an evidentiary standpoint, everything's in front of you.
Okay. Ms. Bryant, you'd mentioned that you wanted some argument. Before I do that, Mr. Howard, did you have evidence or anything that you were planning to call or put on?
I suppose I could stand in my place, Judge, and tell you that would you like me to do that? There's probably 3 things that I need to say.
Okay, briefly, I think that's fair. Go ahead.
Okay. I think one is one, we did the work that's reflected on the bills because, like, the expert witnesses testify, we believe in the position, and the position was that, well, we know what the position is.
Well, yeah, I was gonna say, let me interrupt you. On that point, I will say this. I've not heard anyone say that they believe that you did not do the work that you billed on your bill. I think what I have heard is they believe some of that work was unnecessary and or that it wouldn't have been required for an attorney who had more or better experience in this particular area. And so I don't know that you have to defend yourself. I think it's a valid critique that the court will take into consideration. That some of the work perhaps could have been done more efficiently, but I have not heard anyone assert that you did not do the work that you put on your bill.
Got it. I thought I heard the first expert witness say that I couldn't have, and I was concerned about that. But so I wanted to make it clear that the work that was on the bill was done, and in fact, more work than that. But I'm going to try and avoid slipping into argument. I just think that it's important that I state that, as a matter of fact, based on my experience, one, I don't think this was a typical quiet title case because there were difficult issues to resolve, issues of fact. And 2, I believe, as a matter of my professional opinion, that the amount of time that we spent working on this case was reasonable and necessary to support the fees, and that my hourly rate was required. Also, I think
no one has challenged your hourly rate. It really is just about, are there items of billing that were billed greater than really is justified by the market and or that was unnecessary work? And that's really where my focus is going to be, or was administrative, as we've discussed a few times.
Right. And as a matter of fact, I agree with everybody else that the administrative stuff should be carved out. So that's, I think you can do that with the consent of Ms. Cummings. And that's on me. My apologies. As to the less than accept arguments, as a matter of fact, I think we have a factual basis and legal basis for many of them. I think they're appropriate, but as Your Honor noted in the email ruling, they were never ruled upon. They're fairly complicated academic issues, and I wouldn't expect that we're going to get a ruling on them. But I tried to go in and carve out from my invoices the amount of time we spent dealing with, what was the effect of that less than accept provision. And I came up with a number. I emailed it to the court and everybody else last night. That number was, in addition to the time that I had no charge, an additional, $5,100 or $5,162. That was kind of blended in with other entries. So my testimony is that the less than accept work was a fairly minor portion of this case. The major portion of this case was trying to disprove the allegation that Mr. Jones already owned the property. And as Your Honor knows, we started early in the case with a copy of that 44-220 affidavit, which appeared to show that he didn't own it, but he was trying to buy it from the city. And he said, no, we already own it. And then you know where it went from there. But the majority of the work that we did in this case, up to the part where we moved for attorney's fees was related to this issue of does he really own it, and the various theories that he advanced to us in his pleadings and his motions and other ways about how he did own it. And then, of course, we all know what happened next. The city of Atlanta sold it to him, gave him a quitclaim deed, he paid for it, and then he took the position in the pleading that until then the city owned it. So we know what the facts are. He's stuck with them. I would testify that the amount of time, I think I already did testify, the amount of time we spent on our fees motion was reasonable and necessary because it included having to parse through all of those kinds of issues that I was asking questions about. What does this voluminous document production show? When did he know it? What did he know and when did he know it? And how do we compare this to his privilege log and other things where they're hiding information from us and all of those kinds of things. So I think it was an appropriate amount of time, but I do appreciate that Your Honor is an expert on this and can go through and do what you said you're going to do on Monday, which is you're going to use this as a tool to narrow, and we'll be happy with whatever the court comes up with. We may not agree with it, but we certainly trust Your Honor. So anyway, I thank you for letting me give my testimony on this, but that's it.
Okay. Ms. Bryant? Ms.
Thanks,
Jeff?
Your Honor. I've started talking, so I'll just go and then Ally can go after me. I'll try to be brief. I still am struggling a little bit with the idea that Mr. Howard is pursuing kind of a vague lump sum type attorney fee award. I think that what's required is for there to be a specific identified act and then saying, well, this act enhanced or broadened the scope of the litigation by this amount. And that's how we should be able to arrive at what we're even talking about. So it's been difficult to defend this because all that's been in the record has been an affidavit seeking a very large number, naming lots of parties individually, with little direction about exactly what things were the problem behaviors, in light of the fact that it seems clear that there was an actual title dispute of some kind. I don't think that's in dispute. Furthermore, I think the role of the city of Atlanta is a moving target. They're not in the case. They are protected by sovereign immunity. It is very difficult to sue the city of Atlanta or Fulton County. I could go on for days about that. And they broadened the scope of the litigation, but it appears as though some of that is being attributed to Mr. Jones and counsel. And I'm not sure.
I will, forgive me for interrupting, Ms. Bryant, but I mean, I will say that that was not merely a glib remark to Mr. Tusink. I think that there is a good deal of the work that was done here that was caused by the city of Atlanta's behavior, whether it was bad faith or lack of attention or any number of other gentle adjectives I could apply to it. I do think that that was a large part of this. Number one, in Ms. Cummings' defense, though, I think that Mr. Howard's position throughout the litigation has, as to attorney's fees, has been consistent, which is there was no need to ever have sued Ms. Cummings. And therefore, I'm not saying I agree with that position, but therefore, all of the attorney's fees are recoverable because Ms. Cummings should never have been sued and therefore been required to retain counsel. I'm not saying that that wins the day. And I definitely think that some of the actions that were undertaken here do not lay at the feet of even Mr. Jones and not Mr. Robinson. They lay at the feet of the city of Atlanta. But
okay, and then I just have one last little thing I'd like to say. The use of the word bad faith is not in 91514.
I know.
And so this wasn't a 13-611 motion. And so that has also made it a little bit confusing to defend and a little bit in terms of, some of the line of questioning about going back into things that maybe were part of the last hearing, to the extent that anybody takes the position that Ms. Cummings didn't need to be named in the case. Whether that amounts to the type of egregious or bad faith act when you have a city saying we're not going to comply with things that we're supposed to do until you clear her title interest, I don't know that that amounts to the type of egregious behavior that is typically necessary for an award of attorney fees. So I'll just leave it at that if Ms. Jett has anything else she wants to add.
Your Honor, make sure I'm not on mute. Ms. Bryant covered pretty much everything I would want to say. The only other thing I would point out is obviously in order to prevail on a motion for fees, you have to, you have to have prevailed on the other underlying matter. And here, Your Honor, Ms. Cummings has filed a motion for fees under 915-14A and B. Your Honor has in part denied a portion of that motion and obviously has granted a portion of that motion. I have not seen any evidence that has been submitted to you today or previously that apportions the fees, the amount of time that was spent on fees between the portion that they were successful on and the portion that they were unsuccessful on. Certainly, if you look at the briefing on this matter, the lion's share of the briefing was as to subsection A, which you have denied. I understand that certainly, obviously, the underlying facts probably goes to both, and preparation was as to both issues, but I just don't think that there's the evidence in front of you to make heads or tails of what portion of the ultimate fees award was between those two subsections. So I would ask you to take that into consideration.
Understood. I will add that to the extent that I have spoken inartfully during the hearing today in terms of referencing bad faith, I feel like my ruling was pretty clear that I was finding that Mr. Jones and his counsel in filing the ejectment and the attorney's fees, et cetera, had unnecessarily expanded the scope of the proceeding, that position lacked substantial justification, and that it was brought in bad faith pursuant to OCGA 915-14B. So hopefully my written ruling has been a bit more precise in terms of what I'm actually finding. I do appreciate your reminder to the court about the prevailing party aspects in terms of time spent in seeking fees that was not successful under 915-14A. And so I have made a note of that. Ms. Jett, anything by way of response, Mr. Howard? You're muted.
Sorry, I did that so that I didn't interrupt anyone. And then, of course, just as to the point about apportioning fees between the 915-14A and 915-14B, like the argument is, our argument is really the same for both. And so, we tacked on 915-14B because if you don't, it's foolish because you need to give the judge the discretion to do it. We believe obviously that it would have been appropriate under either section, but Your Honor thinks B was the one. But the argument was really the same for both sections, which is why the 915-14B portion of the brief is very slight. It's but it's all the same argument generally.
I understand.
Thanks, Judge. I would just note that I think both of the expert witnesses, and by the way, I find them both to be very knowledgeable of title litigation and appreciate their testimony, but I think both of them agreed that they did not review the aspects that make this litigation unique from other litigations, and they didn't get into the various correspondences. They didn't get into the various discovery issues. They didn't. It appeared that neither of them reviewed the actual document production. So I would take their testimony, probably limited it for what it's worth. My position with respect to them is that I agree, probably in a typical quiet title matter, you could expect fees in the range of $30,000 or something, but this is not a typical quiet title matter for the reasons that we've discussed. They didn't even file it as a quiet title matter. They filed it as this ejectment claim and this declaratory judgment claim. And by the way, the declaratory judgment claim that they initially filed wasn't even a real declaratory judgment claim. It was just, tell me that I own this property. And it seemed a little tacked on to me. So I think the real thrust of this litigation, as we have always argued, was trying to get Ms. Cummings to sign that certificate of intent under the threat of attorney's fees. And that is why they pled it and did it the way that they did. Ms. Cummings, as you know, she has not had an easy couple of years. reasonably, within a short time prior to this, her husband had committed suicide. She was raising 2 boys in that house by herself. During the course of the litigation, her son had a brain tumor and had to have surgery to remove it. And it has like drastically affected her lifestyle. Her father, who was the person who was funding her lived out in California, and his house burned down in the wildfires, which changed her financial position like rather drastically. And so
Howard,
she,
forgive me. I don't mean to cut you off, and I certainly don't mean to sound uncaring or unfeeling. And I do not. I certainly sympathize with the position in which Ms. Cummings found herself, but I don't know that that is relevant information for the court to consider in determining the amount of fees to be awarded.
well, it may not be, other than the fact, Judge, that that if Your Honor cuts with more than a surgical scalpel, it will leave her with an attorney's fees bill that will be difficult for a person in her position to stomach. And so we just think that she ought not to have been sued in the first place, and she certainly shouldn't have been sued in a lawsuit where somebody was claiming that they owned property that they in fact did not own. And so anything that Your Honor can do to help out with her obligations to our firm would probably be seen as just. That really is that's really all I want to say, Judge.
Okay. Ms. Bryant, anything to add?
Yeah, I mean, I don't believe the standard is for the court to be trying to help out Ms. Cummings. I'm sympathetic to the information that Mr. Howard shared, but I don't believe that would be an appropriate consideration.
I agree with you. I've already said as much. Mr. Howard wanted to make the
I had
point
to address it. I'm sorry.
No, I understand. I understand. Okay. So I am going to take all of this and attempt to issue a ruling sometime soon. I think I've made clear that, well, the claim against Mr. Blazer individually has been withdrawn. I think I've made clear that I intend to make some cuts. And ultimately, I will send you a further email ruling, and will likely ask for someone to prepare a proposed order for me. Or maybe I'll provide one. I'm not really sure what I'll do with it yet, but my goal is to have a ruling for you by the end of the year. I cannot swear to that because I've got about 3 stacked up, and was planning to go on vacation next week. But yeah, Mr. Howard?
Does Your Honor have a copy of the proposed ruling that we submitted previously?
I do in my email. I've not looked at it in any detail, but I do have it.
Understood. Okay, thank you. I just wanted to make sure we didn't not send it.
No, I do have it.
Okay.
Okay. Thank you all for your time and attention and presentation of this matter. And I will wish you all a happy holiday season, and I will see you all later.
Thank you, Judge.
Thank you.
Your Honor, while I have you, I thought I might share a little bit unrelated to this case.
Yes.
But on the issue that we were talking about earlier when Mr. Tusink was testifying about the challengingness of finding special masters
Yes.
in Fulton County. I thought I'd let you know, because I just had my email open in another screen this morning. The Bar's Advisory Committee on Legislation has approved an effort by the real property section of the Bar to submit legislation in this forthcoming session that would expand the residency requirements of special.
That would be so helpful.
Fingers crossed that passes. I just thought I would share that tidbit.
Excellent.
Your
Well,
Honor, may I briefly, make a quick request, just based on conversations with John, similar to what you did in terms of like indicating what the court's ruling would be.
Yes, sir.
Previously. In this, what I wonder is, would it be appropriate to get a similar communication of what the amount of the award would likely be, so that what I'm trying to get at is potentially things can be worked out with Mr. Howard based on the court's ruling of what the number is, short of an official judgment being entered on the docket?
I I'm happy to consider doing that. It is typically my practice to say, this is what I'm going to do. Somebody give me a formal order and I will edit it to my specifications. But I will leave that for Mr. Howard to say that he doesn't mind, in which case what you would get is a follow-up email saying, I've reviewed it. I intend to enter an order that awards this amount. And then if the parties might be able to work something out to avoid a judgment, Mr. Howard, you have seemed agreeable or amenable to trying that in the past. Is that still accurate, sir?
Yes, Judge.
Okay, excellent. Well, then I will do that, Mr.